So visuals back. We are live.
Hi everyone, thank you for joining us today. We'll be starting the event with a song by our friends.
Everybody please join, and everyone knows the song. It's Preeti Guy.
Geeta, please join us. We are singing Preeti Guy.
So actually, Preeti. I'm joining.
Yes, join. ಪ್ರೀತಿಯ ಗಾಳಿ ಬೀಸುತ್ತಿದೆ ಹಟ್ಟಿ ಮೊಹಲ್ಲಗಳ ನಡುವೆ ಗಡಿಗಳ ಮೀರಿ ಗಳತನವ ಮಾಡೋಣ ಬಾ ನನ್ನ ಸಂಗಾತಿಯೇ ಓ ನನ್ನ ಸಂಗಾತಿಯೇ ನನ್ನ ನಿನ್ನ ಈ ಸ್ನೇಹ ಒಪ್ಪದಿರಬಹುದು ಸಮಾಜ ನನ್ನ ನಿನ್ನ ಈ ಸ್ನೇಹ ಒಪ್ಪದಿರಬಹುದು ಸಮಾಜ ತಪ್ಪೆಂದಾದರೆ ನಾಗರಿ ತಪ್ಪು ಮಾಡೋಣ ಬಾ ನನ್ನ ಸಂಗಾತಿಯೇ ಓ ನನ್ನ ಸಂಗಾತಿಯೇ ನಿನ್ನೆ ತಪ್ಪು ಇಂದು ಸರಿ ಇಂದಿನ ತಪ್ಪು ನಾಳೆ ಸರಿ ನಿನ್ನೆಯ ತಪ್ಪು ಇಂದು ಸರಿ ಇಂದಿನ ತಪ್ಪು ನಾಳೆ ಸರಿ ಕಾಲ ದೇಶಕ್ಕೆ ಬದಲಾಗುವುದು ತಪ್ಪು ಸರಿ ನನ್ನ ಸಂಗಾತಿಯೇ ಓ ನನ್ನ ಸಂಗಾತಿಯೇ ಬದಲಾವಣೆಯನ್ನು ಹುರಿದೆ ಮೌಲ್ಯಗಳ ಸಂಘರ್ಷವಿದೆ ಬದಲಾವಣೆಯಲ್ಲಿ ನೋವಿದೆ ಮೌಲ್ಯಗಳ ಸಂಘರ್ಷವಿದೆ ಇಂದಲ್ಲ ನಾಳೆ ಬದಲಾವುದು ಜನಾಮನ ನನ್ನ ಸಂಗಾತಿಯೇ ಓ ನನ್ನ ಸಂಗಾತಿಯೇ ಬದಲಾಗದಿದ್ದರೆ ನಾವೆಂದು ಜಗವ ಬದಲಾಯಿಸುವೆವೆಂದು ಬದಲಾಗದಿದ್ದರೆ ನಾವೆಂದು ಜಗವ ಬದಲಾಯಿಸುವೆವೆಂದು ಬದಲಾವಣೆಯು ಶುರುವಾಗುವುದು ನಮ್ಮಿಂದಲೇ ನನ್ನ ಸಂಗಾತಿಯೇ ನನ್ನ ಸಂಗಾತಿಯೇ ಪ್ರೀತಿಯ ಗಾಳಿ ಬೀಸುತ್ತಿದೆ ಹಟ್ಟಿ ಮೊಹಲ್ಲದ ನಡುವೆ ಹರಿಗಳ ಮೀರಿ ಗಳತನವ ಮಾಡೋಣ ಬಾ ನನ್ನ ಸಂಗಾತಿಯೇ ನನ್ನ ಸಂಗಾತಿಯೇ ಬಾ ನನ್ನ ಸಂಗಾತಿಯೇ Thank you everyone for joining in the song. So once again, very good evening and thank you all for coming here today. We are here to mark the release of our book on the judgment of Supreme versus Union of India. The book explains the judgment and the implications it has. My name is Samprita. I am part of Alternative Law Forum. I'll be speaking a little bit about ALF and the structure of the event today. ALF is a collective of lawyers that has a commitment to respond to issues of social and economic injustice, particularly in areas affecting marginalized communities. As some of you might know, one of our enduring engagements has been with the gender and sexuality rights. They've engaged with the queer community by representing across courts and statutory bodies in bringing out publications and organizing several public discussions. One one of the main areas of our work is to also make law and legal developments accessible to all of us. And this work will be building upon that. My colleague Manvi here will be speaking about the booklet, will be touching upon the themes of the booklet and why it is important that we have this discussion today. And we're also really happy to have Arvind Narayan and Aarti Munpur as our speakers, who will be speaking on the judgment itself and the ways going forward in asserting our rights. After the speakers, it will be followed by a discussion with all of you on what the judgment means to us and the ways for us to collectively go forward. So, thank you again. Over to you.
Thank you, everyone. Most of you anyway already know about ALF, and it's good to see many of you here again. This booklet is titled A Dream. This booklet is titled A Dream Deferred, and it's about, like Samprita mentioned, this year, this month actually marks 1 year of the denial of marriage equality. As all of you will know, last year on the 17th of October, the Supreme Court not only said that marriage equality is not a right we will grant to the queer community, but it also said that there's no fundamental right to marry itself. And so the reason we have titled this booklet A Dream Deferred is inspired from one of the poems of Langston Hughes, who's a writer, an activist, and I just want to read out the poem to give a little bit of context as to why it poetically meant a lot to us in ways of inspiration also. The poem is titled Harlem, and it goes like this. What happens to a dream deferred? Does it dry up like a raisin in the sun, or fester like a sore and then run? Does it stink like rotten meat, or crust and sugar over like a syrupy sweet? Maybe it just sags like a heavy load, or does it explode? And the hope with this booklet and the right of marriage equality is also that while the dream of marriage equality has been deferred, we hope it's a momentary difference, and we hope that the articulation of this right seeps into the public consciousness in a way that we're able to realize it, and the articulation itself explodes from the community in a much, much larger way. The booklet, as Samprita mentioned, how many are lawyers in the room right now? Lost or in counts, but there's not that many, right? And there's a real difficulty in reading judgments which have such a great significance for the questions of fundamental rights and for community rights as a whole. And so our attempt really with this judgment is to be able to divide it into thematics and to be able to present the legal complexity in a very simple way that we're able to digest and understand and articulate what are the ways forward for us, how do we understand this judgment, what are some things that we agree and disagree with. And it was a 5-judge bench, like many of you all will know. Justice Chandrachud, who will be retiring soon, authored the minority opinion. And also something that a lot of us don't know about, that is when the marriage equality case was decided and was pending actually. Parallelly in Madras High Court, there was a case that was filed for the recognition of a deed of familial association. A deed of familial association is nothing but recognizing a live-in relationship, but also looking at Article 21 rights to be granted and the protected status to be provided to those partners in that live-in relationship. And the reason it becomes important to recognize, say, for example, a partnership is to protect them from the harassment from society, the shame that is brought upon by society, and also to be able to access rights within an intimate partnership, right? So this deed of familial association, a petition was filed in the Madras High Court. And the Madras High Court very intelligently relied upon the fact that while the Supreme Court judgment in and of itself, when you look at it, does not grant marriage equality, what it does do is it recognizes your right to be in a union. It recognizes your intimate partnerships. And so drawing from that, it directed the Social Welfare Department to formulate guidelines in a way that deeds of familial associations can be recognized and in what ways, what rights can be granted and so on. What has also happened after the judgment, which a lot of people don't know about, was a series of notifications came out based on the judgment. And these notifications become really, really important because they, in effect, they are what the government institutions and your state authorities rely upon in terms of protecting the rights of queer persons and so on. So even though marriage equality was not granted, you see that the recognition that queerness is a natural phenomenon, it's not an elite concept. You see all of these concepts and all of these arguments that are made before the court has a purchase to it and agrees that queerness is not an concept. It is not unnatural. It is a natural phenomenon. And it goes on to basically lay the groundwork to reiterate the stopping of violence against queer individuals, right? We've previously seen in the decriminalization decision in NALSA that the violence against queer individuals has to stop. And so in these notifications, we see specifically that there's one notification that specifically speaks about that harassment must stop. The police must stop filing false FIRs. There is another notification about the visitation right in prisons of queer persons of their partners, which recognizes that if somebody is incarcerated and if you're in a queer relationship, you have the right to visit them and so on. And similarly, it also recognizes your household as one household. If two queer partners live together, if there's a queer partnership, and by that, what does that mean? To many of us, it may not mean a lot, but for people who have to access ration cards, right, who have to get ration from the ration cards, it means a lot because then you are recognized as one unit in that sense. There was also a notification which specifically talked about the right to healthcare, and that we have to ensure healthcare is provided to queer persons, which is not to basically stopping all kinds of conversion therapy, forceful conversion therapy, all kinds of medical interventions that people do to so to say, quote unquote, cure queerness. So this was another notification. And finally, of course, many people had done this before this notification also came out, but the recognition and a notification specifying that people can open joint bank accounts and there is no bar, so to say, to open joint bank accounts. So while we look at the superior judgment with a lot of critique, disappointment, but we also see the rights that emerge from it in terms of socioeconomic welfare rights for us. And this booklet hopefully will give some sort of ways forward to go into this. And today's discussion is really important for us because it's not just about the marriage equality decision for us. It's also about looking at the paths forward when it comes to the question of LGBTQI rights, whether it's questions of horizontal reservations in terms of employment, whether it's in terms of looking at accessing livelihoods, or in terms of housing. And so it's much broader for us. And that's why if you looked at the poster also, we had framed it around paths forward for LGBTQI rights. As ALF, we've predating me and Samprita, the organization has had a long relationship with the queer community. And we're very happy that we're able to sort of take it forward with the little work that we are doing. And in the next part of it, Arvind will basically talk to us. Most of you all already know Arvind. To those of you who don't, he's an author. He's the current PUCL state president of Karnataka. He's written books like Law Like Love. And yes, and so he has done a lot of work, 2 decades of work, if I'm not wrong, on queer rights, along with being a human rights lawyer. So he's largely going to speak about the judgment and give it to us in a simple, digestible form as to how do we understand it. Followed by that, we'll have Aarti speak to us, who will do something very important, and that's why we felt Aarti was the right person to do this. She's a lawyer, reluctantly a family lawyer also, who's done many years of practice in the family courts. So who really understand the nuances of how marriages and the breakdowns of marriages operate in courts. And so in the demand for looking at, say, for example, the Special Marriage Act as a vehicle, as an act which should include queer persons, what would it have meant? Apart from that, to also look at, she'd bring in her expertise to look at the other forms of rights, right? In terms of succession, in terms of inheritance, in terms of how do we, what is it that we can go forward in the utopian sense, like she likes to say it, if we were to start thinking of the question of partnership and so Aarti will speak about that, and like Sampita said, will be followed in by a discussion with them. So over to you, Aarti.
Thanks, Manu. First, we need to do only in English. ಕನ್ನಡದಲ್ಲಿ ಕೂಡ ಮಾಡ್ಬೇಕಾ? ಅದು ಸ್ವಲ್ಪ ಮಿಕ್ಸ್ ಮಾಡ್ಬೇಕು ಸ್ವಲ್ಪ ಮಾಡಿ. ಸೊ ಈ ತೀರ್ಪಿನ ಬಗ್ಗೆ ಮಾಡ್ತಾರೆ ಅಂತ ಕೇಳಿ ಬಂದಿದ್ದೇವೆ. ಈ ತೀರ್ಪು ನಾವು ಖಂಡನೀಯ ತೀರ್ಪು ಅಂತ ಖಂಡಿತವಾಗಿ ಹೇಳ್ತೀವಿ. ಯಾಕೆ ಇಂತ ಖಂಡನೀಯ ತೀರ್ಪು ಅಂತ ಸ್ವಲ್ಪ ಹೇಳ್ತೀನಿ ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ ಮತ್ತು ಕನ್ನಡದಲ್ಲಿ ಕೂಡ. ಈ this we here to speak about this judgment, and in some ways a judgment 1 year down the line, right? To what extent does it make sense going to the nuances of the majority, the minority, by the majority, the minority, etc. There's one way of thinking about it, but I still think it's useful to go into it because, again, sometimes going into something in the past can really be about the future. To understand, for example, what went wrong in the either in our approach to the advocacy to the judgment, or what went wrong in the judgment itself, and based on that we think of what the future strategy should be. So the question of the past and the future is very linked. ಇದು ಯಾಕೆ ಈ ತೀರ್ಪಿನ ಬಗ್ಗೆ ನಾವು ಸ್ವಲ್ಪ ಅಷ್ಟು ಗಮನ ಕೊಡ್ಬೇಕು ಅಂದ್ರೆ, ಈ ತೀರ್ಪು ಬರೀ ಒಂದು ಪೂರ್ವದ ಮಾತು ಮಾತ್ರ ಅಲ್ಲ, ಭವಿಷ್ಯದ ಮಾತು ಕೂಡ. ಅದು ಇದರಿಂದ ಯಾವ ತರ ನಾವು ಭವಿಷ್ಯದ ಬಗ್ಗೆ ಯೋಚನೆ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗತ್ತೆ ಅಂತ ನಾವು ಯೋಚನೆ ಮಾಡ್ಬಹುದು ಈ ತೀರ್ಪನ್ನು ಇಟ್ಕೊಂಡು. ಈ ತೀರ್ಪಿನ ಹೆಸರು ಎಲ್ಲರಿಗೂ ಗೊತ್ತು, ಸುಪ್ರೀಂ ವರ್ಸಸ್ ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ. It's about the entire question of can you think of the entire question of the rights of the marriage of the LGBTQ community under the Special Marriage Act. And perhaps just a quick point on the judgment itself. The bench is constituted by the Chief Justice, and normally if you consider a bench, you should be in a position to ensure that the majority of the judges are with you, right? And I would think that the Chief Justice did think in that particular way, because you look at the composition of the bench, 3 judges are both Justice Kaul, Justice Chandrachud, and of course Justice Bhatt, have had a progressive reputation. They've come up with a range of very progressive judgments. So you'd imagine that they'd all be on the same side on this question as well. Which, of course, the thing you think of what lies underlying that is a judge-centric approach, right? You're thinking, the petitioners, the lawyers, that the people thinking, hey, we have Chief Justice Chandrachud in place. He will give us marriage equality. He will consider a bench which will get us the judge. So that's the thinking, which I think underlies the entire advocacy effort itself, right? And what happens finally, ಕೊನೆಯಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಒಂದು ಮೆಜಾರಿಟಿ ತೀರ್ಪು ಒಂದು ಮೈನಾರಿಟಿ ತೀರ್ಪು ಬರುತ್ತೆ. ಇದು ಮೆಜಾರಿಟಿ ಏನ್ ಹೇಳುತ್ತೆ ಅಂದ್ರೆ ಒಂದು ಅಂಶ ನಾವು ಗಮನಿಸಬಹುದು. ಈ ಮೆಜಾರಿಟಿ ಮೈನಾರಿಟಿ ಎರಡು ಹೇಳ್ತೀವಿ, ಇಬ್ಬರು ಒಂದು ಅಂಶದಲ್ಲಿ ಇಬ್ಬರು ಅಗ್ರಿ ಆಗ್ತಾರೆ. ಒಂದಂದ್ರೆ ಈ LGBTQ ಸಮುದಾಯಕ್ಕೆ ಹಕ್ಕುಗಳಿದೆ, ಮದುವೆ ಹಕ್ಕು ಕೊಡಲೇ ಇರಬಾರ್ದು, ಅಂದ್ರೆ ಮದುವೆಯನ್ನು ಕಾನೂನು ಪರಿಗಣಿಸಲೇ ಇರಬಾರ್ದು. ಆದ್ರೆ ಇಬ್ಬರು ನೀವ್ ಜೀವನದಲ್ಲಿ ಮಾಡ್ತಾರೆ ಮಾಡಿ, ಅದ್ರ ಬಗ್ಗೆ ನಮ್ಗೆ ಏನ್ ಅಭ್ಯಂತರ ಇಲ್ಲ. ಇಬ್ಬರು ಲೆಸ್ಬಿಯನ್ ಇರ್ಬೋದು, ಗೇ ಇರ್ಬೋದು, ನೀವು ಹೇಗಾದ್ರೂ ಮಾಡ್ತೀರಿ, ಅದು ಪರವಾಗಿಲ್ಲ, ನೋ ಪ್ರಾಬ್ಲಮ್. ಬೇಸಿಕಲಿ ನವತೇಜ್ ಯಾವ ತರ ಒಂದು ರೈಟ್ ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡುತ್ತೆ, ಅದು ಹಿಂದೆ ಹೋಗಲ್ಲ, ಆ ಲೆವೆಲ್ ಅಲ್ಲಿ. ಸೊ ದಟ್ ಮಚ್ ಆಲ್ ಜಡ್ಜಸ್ ಅಗ್ರಿ ಆನ್. ಅದು ಒಂದು ಅಂಶ, ಒಂದು ಲೈನ್ ಅಲ್ಲಿ ಹೇಳ್ಬೋದು. ಡ್ಯೂರಿಂಗ್ ದಿ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್, the central government made the point that the LGBT community is an elite community. ಅವರು LGBT ಸಮುದಾಯ ಅಂದ್ರೆ ಬರೀ ಒಂದು ಎಲಿಟ್, ಬರೀ ಮಿಡಲ್ ಕ್ಲಾಸ್, ಮೇಲೆ ವರ್ಗದವರು. ಅಲ್ಲಿ ಜಾಸ್ತಿ ಏನೋ ನಮ್ಮ ವರ್ಕಿಂಗ್ ಕ್ಲಾಸ್ ಸಮುದಾಯಕ್ಕೆ ಅಷ್ಟೇನು ಕನೆಕ್ಷನ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ. ಅದಕ್ಕೆ ಒಂದು ರಾಜು ರಾಮಚಂದ್ರನ್ ಅವರು ಅದಕ್ಕೆ ಒಂದು ತುಂಬಾ ಒಳ್ಳೆ ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್, ಅದಕ್ಕೆ ತುಂಬಾ ಒಳ್ಳೆ ಉತ್ತರ ಕೊಟ್ಟಿದ್ರು. ಅದು ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ ಹೇಳ್ತೇನೆ. ಅವ್ರು ಏನ್ ಹೇಳಿದ್ರು ಅಂದ್ರೆ, he said the government keeps making the argument that the LGBT community is an elite community, but he said if you go back to he quoted the words of a very well-known judge called Justice Bipin Bose, who made the point. He said that the Constitution is not for the rich and the elite; it's for the butcher, the baker, and the candlestick maker. And then he went on to say, he said, Your Lordship, my 2 clients, one of whom is a lesbian baker from Uttar Pradesh. And the other client is her partner, who's a who's an accountant from Haryana. My lesbian baker, who's my client, is a Dalit woman, and my partner is an OBC woman. Right? And so that I think told you that I'm telling you very briefly. There's a diversity. There's diversity of people before the bench, and the idea of the elite that I think was convincingly rebutted or demolished in the course of this hearing, not just for the court, but I think for all of us. Everybody saw the fact that it's not just a couple of middle class gay men advocating for the rights of the LGBTQ community. It's a wider spectrum of people who are actually passionate and concerned about these kinds of rights. Going back, the judgment itself, would the majority and the minority agree that it's not an elite, is middle class grouping? Would the majority and the minority agree that transgender people who are rigidly in certain rigid gender identities, transgender men are entitled to have a relationship with them. Transgender men ಹಾಗಿದ್ರೆ ನೀವು ಹೆಂಗಸರ ಜೊತೆಯಲ್ಲಿ ಒಂದು ಮದುವೆ ಮಾಡ್ಬೋದು. ಟ್ರಾನ್ಸ್ಜೆಂಡರ್ ವಿಮೆನ್ ಇದ್ರೆ ನೀವು ಗಂಡಸರ ಜೊತೆಯಲ್ಲಿ ಮದುವೆ ಮಾಡ್ಬೋದು. ಅದು ಮೆಜಾರಿಟಿ ಮೈನಾರಿಟಿ ಇಬ್ಬರು ಒಪ್ಕೊಳ್ತಾರೆ. That's one kind of a right. They agree that that the LGBTQ community is not an elite community. ಮತ್ತು ಇನ್ನೊಂದು ಅಂಶದಲ್ಲಿ ಎಲ್ಲ 5 ಜಡ್ಜಸ್ ಅಗ್ರಿ ಆಗ್ತಾರೆ. ಈ SMA ಕೆಳಗಡೆ ಖಂಡಿತವಾಗಿ ನಾವು ಒಂದು LGBT ಸಮುದಾಯಕ್ಕೆ ಅಲ್ಲಿ ಒಂದು ಸ್ಥಾನ ಸಿಗ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. You can't recognize the LGBTQ community as entitled to marry under the Special Marriage Act. That all 5 judges. ಈ ಮೈನಾರಿಟಿ ತೀರ್ಪು ಜಸ್ಟಿಸ್ ಚಂದ್ರಚೂಡ್ ಅವರ ತೀರ್ಪು ಅದರ ಬಗ್ಗೆ ಸ್ವಲ್ಪ ಹೇಳ್ತೀನಿ. ಬಿಕಾಸ್ ಅಗೇನ್ we're thinking of what might be a path to the future. And it is possible to think of the minority judgment as a path to the future. Again, take in mind the fact that Justice Chandrachud is very clear. The SMA you can't think of the SMA as a framework for LGBTQ marriage rights, right? At the same time, he proposes you go on Article 19(1)(c), look at the right to association, and read the right to association as including the right to intimate association. And he says, see, two people can be in a relationship. That everybody agrees. Justice Bhatt agrees, Justice Chandrachud agrees, everybody says, yeah, it can be in a relationship. Justice Chandrachud goes one step further and says, if two people are in a relationship, certain rights flow out of that relationship. And then it is the responsibility of the state to recognize those rights. What are the rights? ಇಬ್ಬರು ಒಂದು ಸಂಬಂಧದಲ್ಲಿ ಇದ್ರೆ ಅದರಿಂದ ಯಾವ ತರ ಹಕ್ಕುಗಳನ್ನು ಬರುತ್ತೆ ಆ ಪ್ರಶ್ನೆ ಕೇಳ್ತಾರೆ. And he says the rights which flow out of a relationship would be, one is of course your right to make medical decisions about your partner should your partner be in a difficult medical situation. Your right to nominate your partner as a on bank loans, etc. All of these rights flow out of relationships, and straight people have those rights. LGBTQ people would have the same rights. He agrees with that. Justice Bhatt, of course, dissents on that point. Right? That's one kind of a important right which the minority puts forward. So again, think about it. What he's proposing is not an SMA framework, but an idea of rights which flow out of 19(1)(c), and which the government should recognize. Justice Bhatt dissents. There's no question. There's no question of the government recognizing any of these rights. There's no question of recognizing your rights which flow out of a relationship. That's a big disagreement between the two. The second point again is the adoption question. ಈ ಅಡಾಪ್ಷನ್ ಪ್ರಶ್ನೆ ಬಂದಾಗ ಕೂಡ ಜಸ್ಟಿಸ್ ಚಂದ್ರಚೂಡ್ ಅವರು ಹೇಳುವ ಮಾತೇನಂದ್ರೆ, ನಾವು ಈ ಕಾರಾಗೃಹದಲ್ಲಿ ಗೈಡ್ಲೈನ್ಸ್ ನೋಡಿದ್ರೆ ಆ ಗೈಡ್ಲೈನ್ಸ್ ಏನ್ ಹೇಳುತ್ತೆ ಅಂದ್ರೆ, ಯಾರು ಅಡಾಪ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಒಂದು ಹಕ್ಕಿರುತ್ತೆ ಅಂದ್ರೆ ಯಾರು ಒಂದು ಮದುವೆ ಮಾಡಿದ್ದಾರೆ ಮತ್ತು ಒಂದು ಲಾಂಗ್ ಟರ್ಮ್ ರಿಲೇಶನ್ಶಿಪ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ, ಅವರಿಗೆ ಮದುವೆ ಮಾಡುವ ಅವರಿಗೆ ಅಡಾಪ್ಟ್ ಮಾಡುವ ಹಕ್ಕು ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದಕ್ಕೆ ಜಸ್ಟಿಸ್ ಚಂದ್ರಚೂಡ್ ಹೇಳ್ತಾರೆ ಇದು ಖಂಡಿತ ಸರಿಯಲ್ಲ. ಯಾಕಂದ್ರೆ ಇಬ್ಬರು ಗಂಡಸರು ಇಬ್ಬರು ಹೆಂಗಸರು ಗೇ ಲೆಸ್ಬಿಯನ್ ಇಬ್ಬರು ಟ್ರಾನ್ಸ್ಜೆಂಡರ್ ಜನರು ಯಾರಾದ್ರೂ ಅಡಾಪ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹಕ್ಕು ಇರಲೇಬೇಕು. ಯಾಕಂದ್ರೆ ಈ ಅಡಾಪ್ಷನ್ ಪ್ರಶ್ನೆ ಬಂದ್ರೆ ಇಟ್ಸ್ ನಾಟ್ ಜಸ್ಟ್ ಲಿಮಿಟೆಡ್ ಟು ಅ ಮ್ಯಾರಿಟಲ್ ರಿಲೇಷನ್. ಅವರು ಹೇಳ್ತಾರೆ ಎಷ್ಟೋ ಸ್ಟಡೀಸ್ ಇದೆ, ನಾವು ನೋಡಿದ್ದೇವೆ, ಈ ಲೆಸ್ಬಿಯನ್ ಕಪಲ್ ಇರ್ಬೋದು, ಗೇ ಕಪಲ್ ಇರ್ಬೋದು, ಅವರು ಒಂದು ಮಗುನ ಸಾಕಿದ್ದಾರೆ. ಅದರಿಂದ ಯಾಕೆ ಹೇಳ್ಬೇಕು ಓನ್ಲಿ ಎ ಮ್ಯಾರಿಟಲ್ ರಿಲೇಶನ್ಶಿಪ್ is the one which can best safeguard the right to best interest of the child. Again, Justice Butt dissents strongly on this. He says, no, you're interfering too much with the adoption with the marital relationship and the best interest of the child. His strong point is the best interest of the child will be deeply affected if you allow people in unmarried relationships to adopt. Again, you get Justice Butt is bias. I think is very strong. Right? It's very disguised, but it's very strong. Very strong in terms of what he feels the queer community cannot do. Right? And so these are the 2 points which are there, which I think are the possibility of the future as far as the minority judgment is concerned. Again, I mean, if you think of a dissent, right? Again, the what Justice Khanna says in EDM Jabalpur, he says that dissent in a court of last appeal is an appeal to the brooding spirit of the law and to the intelligence of a future day. So the only hope we have, if you're taking the judgment as seriously as I'm taking it in this case, is that we hope that the minority voice at some time becomes a majority voice. But then this is in the level of hope and aspiration and dream, right? So the concrete question you have to ask is why did the minority not become a majority? What is the gap? Why did we not succeed in making the minority majority opinion itself? Right. And here I have a couple of points which Aarti is going to elaborate in greater detail on, but I'm going to make these points. See, the question I started with is if you think that Justice Butt is generally a sensitive judge, why on earth were you not able to get him on your side? Right? Why on earth were you not able to appeal to not the intelligence of a future day, but the intelligence of a judge sitting in front of you? Right? What was the gap which happened over there? Right? And here perhaps the broader point I'll make, and which actually the Rohan Butt makes in his book called The Urban Elite. If you get a chance, please do read it. Actually, you should read it because I mean we're coming up with a booklet which is on the judgment, right? But this is a book which is like 1 year post the judgment, looks at the hearings and comes up with also the question of what he analyzes to some extent the question of what went wrong. And the point he makes, and the point which I kind of concur with and I agree with, and I think Aarti agrees with as well, is the idea that ನಾವು ಇಂಥ ಒಂದು ಹೋರಾಟ ಒಂದು LGBTQ ಸಮುದಾಯದ ಒಂದು ಹೋರಾಟವನ್ನು ಮಾಡ್ಬೇಕಾಗಿದ್ರೆ ಅದು ಒಂದು ಸೋಶಿಯೋ ಲೀಗಲ್ ಬ್ಯಾಟಲ್ ಆಗ್ಬೇಕು. It can't be a battle only in the courtrooms. And that's the lesson we learned in the 377 battle. Right? 377 battle was a 17-year battle. And ಕ್ರಿಸ್ಟಿ ಚೆನ್ನಾಗಿ ಗೊತ್ತು ಈ 377 ಬಗ್ಗೆ ನಾವು ಅಷ್ಟು ಹೋರಾಟ ಮಾಡಿದಾಗ ಅದು ಸಮುದಾಯ ಒಂದು ಬೀದಿಯಲ್ಲಿ ಇದರ ಬಗ್ಗೆ ಒಂದು ದೊಡ್ಡ ಒಂದು ಹೋರಾಟನೇ ಮಾಡಿ. It was a struggle which owned the ground level. ಎಷ್ಟೋ ಒಂದು 377 ಬಗ್ಗೆ ಎಷ್ಟು ಪ್ರೊಟೆಸ್ಟ್ ಆಗಿತ್ತು ಅಂತ ಹೇಳಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಬೆಂಗಳೂರಲ್ಲಿ ಇರ್ಬೋದು, ಚಂಡೀಗಢದಲ್ಲಿ ಆಗ್ಬೋದು, ಡೆಲ್ಲಿ ಅಫ್ಕೋರ್ಸ್, ಬಾಂಬೆ, ಭುವನೇಶ್ವರ್, ಎಲ್ಲೆಲ್ಲೋ ಜಾಗದಲ್ಲಿ 377 ಬೇಡ, 377 ಹೋಗ್ಲೇಬೇಕು ಅಂತ ನಾವು ಹೋರಾಟ ಮಾಡಿದ್ದೀವಿ. ಆದ್ರೆ ಈ ಮ್ಯಾರೇಜ್ ಪ್ರಶ್ನೆ ಬಂದಾಗ ನೀವ್ ಹೇಳಿ ಎಲ್ಲಾದ್ರೂ ಒಂದ್ ಜಾಗದಲ್ಲಿ ಆದ್ರೂ ಒಂದೊಂದು ಹೋರಾಟ ಆಗಿತ್ತ? ಒಂದ್ ಜಾಗದಲ್ಲಿ ಯಾರಾದ್ರೂ ಹೇಳಿದ್ರ ನಾವು ವಿ ವಾಂಟ್ ಮ್ಯಾರೇಜ್ ಈಕ್ವಾಲಿಟಿ ನಾವು? ಆ ಪ್ರಶ್ನೆ ಎತ್ತುವ ಮುಂಚೆನೆ ನಾವು ಕೋರ್ಟಿಗೆ ಹೋಗಿದ್ದೀವಿ. So it's a bigger, I think a fundamental flaw which happened here is we didn't think what this battle is a social legal battle. Again, when you say social legal battle, what I mean is you think of it almost how would we put it? It's two strands of a DNA which are tightly woven together, right? And one strand plays off on the other strand, right? And I don't mean this in a purely metaphorical sense. I'll give you a very concrete example of this, right? When the 377 struggle was going on, right? In the protests happening on the streets, it comes up in the petition before the court, and the government says, the then BJP government says, on affidavit, there are no lesbians and gays in India. That's their submission. The court's response is, counsel, what are you saying? You've seen protests on the street? Simple point of the link between the social and political and the legal, right? And a similar point I'll make again on the link between the two is during the 377 battle, there's a petition, one petition filed by the parents of LGBTQ persons, right? And again, that is a very moving petition. ನಾವು ಆ ಸಮಯದಲ್ಲಿ ನೋಡಿದ್ರೆ ಬರ್ಕಾತ್ ದತ್ ಎಪಿಸೋಡ್ ಒಂದಿತ್ತು, ಅದರಲ್ಲಿ ಬರ್ಕಾತ್ ದತ್ ಮತ್ತು ಟಿವಿ ಸ್ಟುಡಿಯೋ ಅಲ್ಲಿ ನಿತಿನ್ ಮತ್ತು ಅವ್ರ ತಾಯಿ ಇದ್ರು, ಬೇರೆ ಮತ್ತು ಅವ್ರ ತಂದೆ ಇದ್ರು. ಅವರೆಲ್ಲ ಅಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಮತ್ತು ತಾಯಿ ತಂದೆಯವರು ಏನ್ ಹೇಳಿದ್ರು ಅಂದ್ರೆ ಈ 377 ಹೇಳ್ತೇವೆ ಅದು ನಮ್ಮ ಒಂದು ಕುಟುಂಬದ ಒಂದು ರಕ್ಷಣೆಯನ್ನು ಪೀಡಿಸ್ತದೆ. ಅಂದ್ರೆ ನಮ್ಮ ವಿ ಕಾಂಟ್ ಎಂಜಾಯ್ ಅ ಫ್ಯಾಮಿಲಿ ಲೈಫ್ because of this thing called 377. I'm scared that my son may not come home, that he could get arrested, the cops could take him away, etc., etc. Right? And I'm scared, or rather, because of 377, he or she does not feel comfortable to express who they are. Right? So the range of ways in which the law affects my right to peaceful enjoyment of my family life. Therefore, the law must go. Again, you get a sense of the legal, the social, the political, the cultural. All of them have to come together. And that's your imagination of a social movement and a legal battle, which really uh, comes together. So that's, I think, in a sense, if you're saying if you say, okay, let's get down to that point. If you're saying a path to the future, right? A path to the future. Let's go back to the petition. Our petition ನೋಡಿದ್ರೆ ಅಲ್ಲಿ there 18 petitioners ಇದ್ರು. ಅಲ್ಲಿ ನೋಡಿದ್ರೆ ಅಲ್ಲಿ ಡೆಲ್ಲಿ ಇರ್ಬೋದು, ಬೆಂಗಳೂರು ಇರ್ಬೋದು, ಒರಿಸ್ಸಾ ಇರ್ಬೋದು, ಯು ಪಿ ಇರ್ಬೋದು, ಎಲ್ಲಾ ಜಾಗದಿಂದ ಬಂದಿದ್ರು. ಮತ್ತು ನಮ್ಮ ಸಮುದಾಯದ ಒಂದು ಡೈವರ್ಸ್ ಇದೆ, ವೈವಿಧ್ಯತೆ ಆ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ರೆಪ್ರೆಸೆಂಟ್ ಆಗಿತ್ತು. ನೋಡ್ಬೇಕಾಗಿದ್ರೆ ಲೆಸ್ಬಿಯನ್, ಗೇ, ಬೈಸೆಕ್ಸುವಲ್, ಟ್ರಾನ್ಸ್ಜೆಂಡರ್ ಎಲ್ಲರೂ ಆ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಇದ್ರು. ಡಿಫ್ರೆಂಟ್ ಕ್ಲಾಸ್ ಬ್ಯಾಕ್ ಗ್ರೌಂಡ್ಸ್ ಅಲ್ಲಿ ಇದ್ರು. ಸೊ ಆ ಕಥೆಗಳನ್ನು ನಾವು ಮುಂದೆ ತಗೊಂಡು ಹೋಗ್ಬೇಕಾಗುತ್ತೆ. ಸೊ ತಿರುಗಿ ಇಫ್ ಯು ಪುಟ್ ಇಟ್ ದಟ್ ವೇ, and maybe I'll just make this point this way. If you look at the US context, right, they do a very important task of taking forward the law in a broader social legal context. In the sense, right, I mean, I'll give you two examples. There's a book on the Lawrence litigation. It's called Flagrant Conduct, which looks at the petitioner John Lawrence and everything around it, right? There's another great book on Loving vs. Virginia, which is the case on the anti-miscegenation law, which is called Tell the Court I Love My Wife, right? Which is again about the entire question of miscegenation, right? And the question of fighting these laws which prohibit people from marrying across lines of race. And in the Indian context, we look at it that way. What we have is, again, Rohit Dey's very marvelous book called A People's Constitution, which looks at the people behind the litigation, right? People behind the challenge to the cow slaughter law, the people behind the challenge to the ITPA and the ITPA legislation in the Indian context. And my submission, or my proposal, I'm putting it before in every forum I go to, and we hope somebody will take it up, is I think there's a case to be made for doing a book on the marriage petition, right? A case to be made where you take forward the stories of each of the individual petitioners, put it together as a way to educate more and more people about what marriage means or why we're fighting for marriage. And that's a point which I don't think has got to. ಇಷ್ಟವರೆಗೆ ಎಲ್ಲರಿಗೂ ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ಲ ಯಾಕೆ ನಾವು ಈ ಮ್ಯಾರೇಜ್ ಬಗ್ಗೆ ಯಾಕೆ ನಾವು ಇಷ್ಟು ತಲೆ ಕೆಟ್ಕೊಳ್ತದೆ ಅಂತ, ಯಾಕೆ ನಾವೀಗ ಈ ಮ್ಯಾರೇಜ್ ಹಕ್ಕು ಬೇಕು ಅಂತ ಎಲ್ಲರಿಗೂ ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ಲ. ಅದು ನಾವು we have to make people understand that, which means you take these stories forward. I'll end with one last story. ಈ ಕೇಸ್ ಇವಾಗ ಈ ತೀರ್ಪು ಬಂದ ಮುಂಚೆನೆ ಬಂದ ಮೇಲೆನೆ ಒಂದು ತೀರ್ಪು ಬಂತು, ಜಿಬಿನ್ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ ಕೇರಳ ಅಂತ. ಆ ಜಿಬಿನ್ ಸ್ಟೇಟ್ ಆಫ್ ಕೇರಳ ತೀರ್ಪು ಎಲ್ಲರೂ ಓದ್ಬೇಕು. ಆ ಜಿಬಿನ್ ತೀರ್ಪಿನಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ, ಈ ಜಿಬಿನ್ ಎಂಬ ಒಬ್ಬನು ಈಸ್ ಇನ್ ರಿಲೇಶನ್ಶಿಪ್ ವಿತ್ ಸಮನ್ ಕಾಲ್ಡ್ ಸುಬಿನ್ I think, and it's very tragic that Subin dies out of some kind of falls off the top of the house he's living in, right? And he dies in hospital. And Jibin says, ನನಗೆ ನನ್ನ ಪಾರ್ಟ್ನರ್ ದೇಹ ನನಗೆ ಬೇಕು. I want the body. I want to look after. I want to take the body. ಅದಕ್ಕೆ ಹಾಸ್ಪಿಟಲ್ ಅವರು ಹೇಳ್ತಾರೆ, ನೀನ್ ಯಾರು, ನಿನ್ಗೆ ಯಾಕೆ ಈ ದೇಹ ಕೊಡ್ಬೇಕು, ನಿನಗೂ ಅವನಿಗೆ ಯಾವ ತರ ಸಂಬಂಧ ಇರುತ್ತೆ, ಸಂಬಂಧ ಇದ್ರೂ ಕೂಡ ಕಾನೂನು ಆ ಸಂಬಂಧ ಪರಿಗಣಿಸುವುದಿಲ್ಲ. The law doesn't recognize. You might be living together 5 years, but the law doesn't recognize your relationship. So I can't. The hospital says we can't give you this body. It's a very tragic kind of deeply tragic kind of a situation where you can't pay your last respect to somebody you love. Right? And finally, of course, the court in this case finds a way forward. And again, one of the lawyers the lawyer is interested as a transgender person. She did a fantastic job in arguing this matter. And the order she got for Jibin is to say that the body is released to the family but Jibin is allowed to be there to pay his last respects. That's the best that could happen. So which tells you again, right, the vitality and the importance of having a legal recognition of a relationship which might be so deep, right, and which might be so important, so meaningful. And that's the critical kind of a gap which we feel, which we see, which needs to be addressed in the in the time going forward. I think there are a range of other ways as well in terms of the future. But the one point I want to make here is I think since I'm making the case we need to get away from a fully court-centered approach, and since as Manvi found out, not everybody here is a lawyer or law student or necessarily a law person. So what can everybody else do? What can everybody do as far as the question of marriage equality is concerned, right? And so the broad point I'll end with this is I think there's a lot of space and a lot of thing to be done in terms of a broader kind of a public education. Public education in terms of the idea that it's totally natural, normal, the fact that it's integral kind of rights are violated, the fact that it's very, very important that the law recognize the relationship of two people is something we need to seed in a deeper way. People haven't got that idea fully as yet. People understood the question of decriminalization. Again, not all people, but in terms of media, in terms of a range of spaces, people have got that idea. But the marriage idea, I don't think is seeded as deeply as yet. I think we had a great opportunity during the hearings, also because the hearings were telecast live, went to every home really. And so that's a fantastic starting point. But I think we shouldn't stop it. We should start taking that idea forward and ensure there's a wider conversation on the question of marriage equality and why it's so critical, why it's so vital. And that's a responsibility we all have. But I think there are a range of other paths forward, and I'll come in again with post Aarti's very specific range of points which Aarti has in terms of what we can do as far as marriage equality is concerned. Aarti,
Thanks, Arvind. Um, I'm going to take from Arvind's. I think one of the things that we seriously did not consider is the fact that we went with a very law-centric court-based strategy and approach on a question like this. And I think what we have missed the boat on, there are two problems with going directly into the Supreme Court on a claim like this. One is if you lose, you've lost in the Supreme Court of India. There is apparently a review pending on this judgment, but I'm not very hopeful that you're going to see a dramatic turnaround in a review process once you've had this kind of majority of 4 and a minority of 1, and minority of 1 still agreeing with the majority on the fact that we can't give you this in the SMA, in the Special Marriage Act structure. So you, in some way, temporarily, for a longish period of time, barred yourself from going back to the highest court in the country on a claim like this. That's one. So I'm just curious about strategically why this was not tested in a progressive high court. Why did we not strategize as lawyers along with the community to approach one particular high court and test this to see what happens? This is what was done in all your rounds of NAS strategically, right? There's the reason why you did not go rushing to the Supreme Court and you went to the Delhi High Court and you worked your way through that chain of command, as it were, working your way upwards to Supreme Court. So I'm just curious about why these, and I think Arvind hit that nail on the head. You thought that you had a really progressive bench in the Supreme Court of India and you thought you would get this, which I think has had serious consequences. I think we are now on the back foot in one sense because you are in a position where I'm wondering what the urgency to rush to the Supreme Court on this particular question was. It's a extremely complex question. What you're asking the court to do, in effect, is to legislate and to read the Special Marriage Act in a particular way. This includes the way
bride and bridegroom are defined in the Special Marriage Act. The age of 18 and 22 years laid down in the Special Marriage Act. It has repercussions for the Indian Succession Act. It has repercussions across the board in terms of adoption. And I thought there were a plurality of voices. One of your petitioners in this petition was asking for a recognition of what they were calling a chosen family, which had nothing to do with the Special Marriage Act at all. So you had too many things, as opposed to your 377 demand, which was a very crystallized, sharp demand, which was the section ought to go or ought to be read down in a particular fashion. So I think strategically there was, I'm going to say, something lacking in terms of what we conceived of in structuring a case like this. But having said all that, we have Supriyo, we are on the other side of it. It's been 1 year and so on and so forth. Now, what is this imagination that we are trying to capture? In the petitions, you're asking for a right to marry. You're asking for a right to marry under a specific legislation of the Special Marriage Act. How much and how wide a consultation was done with lawyers who may not have practiced or have anything to do with queer rights activism, but who know how the Special Marriage Act works, right? To want to come under a framework that is so flawed in so many ways. The Special Marriage Act comes with a 30-day notice period to be given. We are seeing already the backlash of interfaith communities giving notice of 30 days, even though they otherwise qualify, they're straight, you're already, the Special Marriage Act comes with a host of other problems which has been uncovered. It comes with an inbuilt inequality which favors Hindus in a particular way. Hindus who marry under the Special Marriage Act still get the benefit of the Hindu Succession Act, whereas other two people who marry are disqualified from their personal succession and necessarily have to come under the Indian Succession Act. There are a number of inequality problems ingrained within the Special Marriage Act itself. Having said that, is there a discussion? Has there been a discussion on what it means to get out of a marriage? Everyone is talking about getting into one. We want the road in, but there is a very complex route on the way out. And that requires you to satisfy a good enough reason that the Special Marriage Act tells you is good enough. Adultery, cruelty, desertion, bigamy, unsoundness of mind, so on and so forth, right? So when there is a clamor, when there is a loud voice that says we want to necessarily fall within the purview of the Special Marriage Act, the question that I'm asking is, has there been a serious enough introspection of what it means to be married under the Special Marriage Act at one level? What does it mean to be married, period? Where has there been, and this is a question I'm not just asking of queer people, I'm asking this generally of in any particular situation, where now you see marriage, the thing with marriages, and I think this is the motivator, and I know that Professor John is here and this is some of her work, is that it is the only social security mechanism that exists for a number of women in this country. If you are not married, you're not educated, you do not have a way of earning your own livelihood, you're in a seriously perilous situation. Your health, your life, your relationships, your family, who is going to take care of you when you are old? Do you have people you can depend on? All of these things are in a very serious state of jeopardy. You have nowhere to go. Your natal family typically does not want to have you for more than a certain number of years of you living with them. Where is your future? And your future lies in getting married, which is why there is such a heavy investment of the state in the institution of marriage. This is why it makes it so difficult for you to get out of it as well. Now, when you are speaking from, when queer people are asking for this, are they imagining all of these particular concerns? Are they thinking about financially dependent spouses? Are they thinking about exactly how they plan to negotiate their lives? And my concern is not for the elite LGBTQI couples. My concern is for those who are living on the lower side of that socio-economic spectrum. It is an extremely complex terrain of that you are asking the law to negotiate for you. You are inviting, when you are making this claim, you are inviting the law into that particular aspect of your life, right? So my concerns have been primarily about what thinking have we gone into before we are structuring these claims, which is obviously not to say that I do not very strongly believe that there needs to be a series of alternatives that need to be presented on how it is we live our particular lives, right? Different countries have done this. A lot of states in the US permit marriages. They have gone through the process of creating legal structures that allow for marriages to take place. They contemplate what has to happen to children, etc. We need to go through that process. We need to understand those processes before we land up in a court of law, which is, and in my mind, I think that this ties in with a series of feminist concerns that we have about marriage. It is, marriage has been at the central, if not one of the most central areas of interrogation that feminist groups in this country have done. Perhaps I will say not enough, in the sense that we tend to fall back to the position of how do you make marriages more equal. So you're trying to rework currently, frameworks that exist to make them more equal. But we haven't spent enough time thinking about that utopian legal system. What is that? What are those set of principles? What are those set of ideas that we believe are at the fundamental core of a relationship of equality? And if we are not able to start articulating and thinking about what those are, making a claim for being recognized under the Special Marriage Act, to me, seems like a very short-sighted sort of move. We have to ask ourselves the much bigger questions. And that's not just for LGBTQ people. LGBTQ people have a very unique opportunity to push that discussion, because there is nothing that currently provides them any sort of protection. There is no framework. There is nothing to go to. Which means the questions I want to ask is things like housing, things like getting loans together, things like bank accounts, medical decisions, all of these things, right? We need to sit down and ask ourselves how it is that we ingrain these things without necessarily falling into what I am calling the trap of the Special Marriage Act, because I do think that the Special Marriage Act itself requires a complete rework in terms of its imagination of being the civil a law that is available to all communities, all castes, etc. That it needs a very serious rework from ground up, right? In itself, even if it is applicable only to heterosexual couples, it needs a rethink completely. So asking to be brought into the framework of the Special Marriage Act, I don't think answers what I think are the more critical questions of what it means to be in an equal partnership. And partnership is only one aspect of it. There are people who live in a variety of other ways. People live with friends. I know people who are in very complex arrangements of how their houses run, but none of these people are in intimate relationships with each other. They're living as a group of friends live in a house. Do they need to be Are they seeking some kind of regulation as well? Because once you invite the law into your home, then you are going to grant it a certain power to tell you how you run it, how you actually operate your own intimate life. That is what you are telling the law, that you will be the subject to those proceedings. And I don't think that the Special Marriage Act is an answer to that by any stretch of imagination. I don't even think it's an answer to it for heterosexual people, as in as much as I think that the Hindu Marriage Act falls drastically short of addressing a number of questions. Feminists in this now are thinking about equal division of marital property. What happens when you have two spouses who are very differently placed in terms of how they have contributed to the acquisition of marital assets? What happens, and this I'm still, what happens in cases of severe cases of disability? All of these questions, I think, need far more exploration before we arrive at what we think is a particular sort of solution to the problem. And in any event, I don't think that the Special Marriage Act offers you any answers in this direction at all. So what I have been thinking about for a long time now is whether we see it in the form of a uniform civil code. And I know those three alphabets, UCC, cause a lot of tension in feminist circles and otherwise, because we're deeply concerned about what type of uniform civil code the state will give us, etc. Whether the state gives you something or not is one thing, but what is the type of imagination of a code that you have? What is it? And we need to start putting in energies into that. And that is what I think forms a part of what Arvind was referring to in terms of working this ground up. Because if you don't work it ground up, you are not going to be able to capture the multiplicity of voices, or you're not going to be able to make choices that you need to make in a particular situation like this. The problem with working this ground up is that it's decades and decades of work. In the meantime, you continue to have people who are deprived of exercising rights of adoption and so on, etc. You're working off the backs of their discrimination in effect. But this is the nature of the beast as far as all feminist struggles have been in court as well. If you look at all your big feminist judgments, whether they come from Chabano or whether you look at the critique of your Mathura rape case, etc., they are all off the backs of women who have suffered deep, deep injustices in order to push something forward. And while I'm not proud of saying that is the suffering that people have to go through in order to push something, I do believe that an investment in that sort of thinking through is critical. So the failures, if you're looking, I don't see Suprio as too much of a failure, to be very honest, because I don't think that the Supreme Court could have granted you a reading of Special Marriage Act in a particular way that allows two people of the same sex, or any two people, irrespective of what their biological or chosen genders are, to get married. I never thought that the Special Marriage Act could ever be read in that fashion by the Supreme Court of India. I'm not terribly, to be honest, disappointed that you didn't get it, because if you had got a reading of Special Marriage Act in the way that it had been asked for, that would have been the final thing you would have ever got from the state. There's nothing more that you could have pushed for in terms of recognizing other types of relationships. You would be stuck only with marriage. And is that the final word, as it were, in terms of capturing the diversity of relationships that people engage in? So for me, the reading, the non-getting of Suprio should act as an impetus, should be the impetus to asking fundamental questions about marriage, whether LGBTQI or not, number one. Number two, about this collective thinking about what we want as that, I'm calling it uniform civil code because I like the idea that you can have a utopian civil code that captures any two people entering into a particular sort of relationship of responsibility and care towards each other, whether it is in the form of marriage or not, and irrespective of what their genders and chosen what their chosen genders are, right? I think that the Uniform Civil Code allows for that opportunity. Of course, we are in a serious, the problem with the Uniform Civil Code is that it always hangs as a sword on our necks, because every government, every so often, the government raises it. You have one in Uttarakhand right now, which is a disaster in several respects, but recognizes and requires registration of live-in partnerships and a regulation in that form in a particular way. So obviously that is not the road that one is thinking of. But to begin to imagine what that state of utopian existence is, what allows us to enter and exit from relationships that we choose without falling into necessarily the trap of every single marriage statute that exists today, is the question that I think we need to ask. And we need to ask, what are the fundamental principles on which such a civil code or such a civil partnership, whatever one calls it, will stand? Without asking those questions of ourselves, I thought it was a bit premature to go to the Supreme Court on a claim like this, because it may not be that every single person wants that marriage. And if you get that, that's all you're going to get. You are not going to see any further progressive realization of any other kind of formulation or any other kind of imagination from the state. The state is giving you what it already has. It has Special Marriage Act. It's telling you we're making it applicable to you, despite the severe complications that there may be for succession, etc. We'll figure that out later. But yeah, you want marriage, here it is. And that's it. And that would have been the full stop to any sort of imagination question that I think there is. So while Suprio is a disappointment in many ways, because I do believe that there is a large segment of the LGBTQI community that is quite willing to be in that mode of marriage in the way that the Special Marriage Act envisages it, right? There is something more to be done here. And that something more is not going to come from a court. It is not going to come from the state. It can only come from a series of very deep introspections that need to be done. The way the challenge and the difference between 377 movement and this is that you had a singular enemy in 377. There was no ambiguity. There was no question that 377 had to go. Like nobody would. But here you have a completely different challenge at hand, because you have far many more voices articulating many complex questions of adoption, surrogacy, which comes up very often, and a lot of queer people come to consult me on how they can circumvent the new surrogacy law that exists, because they want a biological child that is born to them. So you have many layers of this, which a simple solution of giving you marriage under the Special Marriage Act is not going to solve. It is not going to be that single answer is not something that addresses the complexity of what life actually throws at you in terms of how you wish to live in a partnership, whatever the nature of that partnership might be. So I am beginning to think that there needs to be some serious investment in this project. I've had an interest in it, not only from LGBTQI voices, which I think have a very important say in this, but actually from a far more traditional, conventional feminist voice that obviously we've been working with these marriage statutes now for whatever, since 1955, 1954, this is 2024. We have a collective experience of what it has meant to articulate for women in courts, from the landscape of these statutes. We have enough of those types. We have enough of that experience. How do we translate that experience into now what we demand from the state? And that is what I think I am sort of more particularly interested in personally. But I think the LGBTQI community has a very strong voice in this, because at this point of time, there is very little that offers you. I mean, it's things like this. We are speaking today about marriage equality. We are living in a current situation where the new Indian penal, the BNSS, is it? The BNSS has been enacted. They have been so bold as to remove the old Section 377, but they offer no protection at all for a person who is not born a woman from sexual violence. So right now we are existing in a situation where you have a new penal code in place, which does not even imagine that there can be sexual violence on a non-female body, right? We've taken one step forward in deleting 377 and 2 steps back, because in the old 377, it was still just read down. So because it was read down, it still existed on the statute book in order to cover non-consensual sexual violence amongst people who are not a man or a woman, which would be covered under rape or what is now called sexual assault. And now you take one step forward, you delete 377 from the BNSS, and you offer no protection to non-female bodies on sexual violence. So what are we in the business of? We're in a seriously difficult position vis-a-vis the state, right? I mean, this begs the question of, at this point of time, today, what would a person who is not born a woman do in the face of being sexually assaulted? And the answer to that question is that we have nothing right now. We will have to rely on some other provisions of the BNSS of grievous hurt, maybe criminal intimidation, assault, or other provisions which don't squarely speak to sexual violence in a particular kind. So we are still living in a state that believes that the only body that can be sexually violated is that of a woman, and that is a person who's born a woman, I would imagine. Right? Because woman is defined in a particular way under the statute, so on and so forth. So you see, I guess what I'm trying to say is that the situation is extremely, extremely complicated, and the answer to it would not have been, I don't think it would ever have been, to go to the Supreme Court saying, read bride and bridegroom in a particular way, and this pretty much solves the entire gamut of problems, because then we can all be married under the SMA, and this takes care of a number of things. It doesn't. It perhaps recognizes marriage and under the SMA, what are rights and responsibilities of spouses in a marriage. That's what it does, and that's all it does. It doesn't do anything more than that. And I think the question that we need to ask is a much, much larger one than being confined to whether you should have the right to marry or not. The question is, how should you be able to allow to access the full range of what your life means, which is beyond necessarily the idea of marriage. So I'll stop with that. I think, is there anything else that
We'll do a quick translation.
Sure.
And then
Thanks.
ನಾನು ಅವ್ರು ಏನ್ ಹೇಳಿದ್ರು ಅದನ್ನ ತುಂಬಾ ಬ್ರೀಫ್ ಆಗಿ ಟ್ರಾನ್ಸ್ಲೇಟ್ ಮಾಡಕ್ ಟ್ರೈ ಮಾಡ್ತೀನಿ. ಅವರು ಫಸ್ಟ್ ಏನ್ ಪಾಯಿಂಟ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ರು ಅಂದ್ರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ನಾವು ಅಪ್ರೋಚ್ ಮಾಡಿದ್ರಿಂದ ಈ ಕೇಸ್ ನಲ್ಲಿ ನಾವು ಸೋತಿದ್ದಾಗ ಇಲ್ಲ ಇವಾಗ ಆಗಿರೋ ತರ ಸೋತಿರೋದ್ರಿಂದ ರಿಕೋರ್ಸ್ ನಮ್ಗೆ ಇದರಿಂದ ಇರೋ ನೆಕ್ಸ್ಟ್ ಸ್ಟೆಪ್ಸ್ ತಗೊಳಕ್ಕೆ ಇರೋ ಜಾಗಗಳು ತುಂಬಾ ಕಡಿಮೆ ಇದೆ. ಮತ್ತೆ ಇದನ್ನ ನಾವೇನು ಈ ಸ್ಟ್ರಾಟಜಿಯಲ್ಲಿ ತಗೊಂಡ್ ಹೋಗಿದೀವಿ ಇದನ್ನ ನಾವು ಬೇರೆ ಪ್ರೋಗ್ರೆಸಿವ್ ಆಗಿರೋ ಹೈಕೋರ್ಟ್ಸ್ ಅಲ್ಲಿ ಒಂದು ಸ್ಟ್ರಾಟಜಿ ಆಗಿ ಟೆಸ್ಟ್ ಮಾಡಿ ನೋಡ್ಬೋದಾಗಿತ್ತು. ಡೈರೆಕ್ಟ್ ಆಗಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಗಿದ್ರೆ ನಮ್ಗೆ ಅದು ಫೈನಲ್ ಕೋರ್ಟ್ ಆಫ್ ಅಪೀಲ್ ಆಗಿರೋದ್ರಿಂದ ನೆಕ್ಸ್ಟ್ ಜಾಗಗಳು ಕಡಿಮೆ. ಮತ್ತೆ ಸೆಕ್ಷನ್ 377 ಡಿಕ್ರಿಮಿನಲೈಸೇಷನ್ ನೋಡುವಾಗ ಅದು ಈ ಮ್ಯಾರೇಜ್ ಇಕ್ವಾಲಿಟಿ ಕಂಪೇರ್ ಮಾಡಿದಾಗ ತುಂಬಾ ಒಂದು ಸಿಂಪಲ್ ಆಗಿರೋ ಒಂದು ಲೀಗಲ್ ಕ್ವಶನ್ ಆಗಿರುತ್ತೆ. IPC ನಲ್ಲಿ ಡಿಕ್ರಿಮಿನಲೈಸ್ ಮಾಡ್ಬೇಕು ಅಂತ ಮಾತ್ರ. ಬಟ್ ಮ್ಯಾರೇಜ್ ಇಕ್ವಾಲಿಟಿ ಅಂತ ಬಂದಾಗ ಇಲ್ಲಿ ಸ್ಪೆಷಲ್ ಮ್ಯಾರೇಜ್ ಆಕ್ಟ್ ಇದೆ, ಸಿವಿಲ್ ಯೂನಿಯನ್ ಇದೆ, ಮತ್ತೆ ಚೋಸನ್ ಫ್ಯಾಮಿಲಿಗೆ ರೆಕಗ್ನಿಷನ್ ಇದೆ. ಸೊ ಇದು ಅದರಷ್ಟು ಸ್ಟ್ರೇಟ್ ಫಾರ್ವರ್ಡ್ ಆಗಿ ಇರ್ಲಿಲ್ಲ. ಬಟ್ ರಿಗಾರ್ಡ್ಲೆಸ್ ಇವಾಗ ನಾವು ಈ ಜಾಗದಲ್ಲಿ ಇದೀವಿ, 1 ವರ್ಷ ಆಗಿದೆ ಜಡ್ಜ್ಮೆಂಟ್ ಬಂದು. ಬಟ್ ಇವಾಗ ನಾವು ಏನ್ ಕೇಳ್ಬೋದು ಅಂದ್ರೆ ಇದಕ್ಕೆ ಎಷ್ಟು ಕನ್ಸಲ್ಟೇಷನ್ಸ್ ಮಾಡಿದ್ದಾರೆ, ಗ್ರೌಂಡ್ ಅಲ್ಲಿ ಜನರ ಜೊತೆ ಎಷ್ಟು ಇವರು ಮಾತಾಡಿದ್ದಾರೆ, ಮತ್ತೆ SMA ಕೆಳಗಡೆ ನಮಗೆ 30 days ನೋಟಿಸ್ ಪೀರಿಯಡ್ ಅಂತ ಒಂದು ಪ್ರಾವಿಷನ್ ಇದೆ. ಅದನ್ನ ಯಾವ್ದನ್ನು ಅಡ್ರೆಸ್ ಮಾಡಿದಾರಾ ಇಲ್ವಾ ಅನ್ನೋದು ಗೊತ್ತಾಗಿಲ್ಲ. ಮತ್ತೆ ಸೆವೆರಲ್ ಪಾಯಿಂಟ್ಸ್ ಈ ತರ ಅವ್ರು ಮಾಡ್ತಾರೆ. ಫೈನಾನ್ಷಿಯಲಿ ಡಿಪೆಂಡೆಂಟ್ ಆಗಿರೋ ಪಾರ್ಟ್ನರ್ಸ್ ಬಗ್ಗೆ, ಮತ್ತೆ ಡಿಸೇಬಿಲಿಟಿ ಇರೋ ಪಾರ್ಟ್ನರ್ಸ್ ಬಗ್ಗೆ ಇದು ಯಾವ್ದನ್ನು ಸ್ಪೆಷಲ್ ಮ್ಯಾರೇಜ್ ಆಕ್ಟ್ ಆಗಿದ್ರೆ ನಮ್ಗೆ ಅಡ್ರೆಸ್ ಮಾಡೋದಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಮತ್ತೆ ಬೇರೆ ಎಲ್ಲಾ ಕಂಟ್ರೀಸ್ ಇದನ್ನ ತಗೊಂಡ್ ಬಂದಿದ್ದಾರೆ, ನಾಟ್ SMA ಬಟ್ ರೆಕಗ್ನಿಷನ್ ಆಫ್ ಸೇಮ್ ಸೆಕ್ಸ್ ರಿಲೇಶನ್ಶಿಪ್ಸ್ ತಗೊಂಡ್ ಬಂದಿದ್ದಾರೆ. ಬಟ್ ಆ ಪ್ರಾಸೆಸ್ ಇಂಡಿಯಾನಲ್ಲೂ ಅದೇ ಪ್ರಾಸೆಸ್ ನ ಫಾಲೋ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ಮತ್ತೆ ಒಂದು ಫೆಮಿನಿಸ್ಟ್ ವ್ಯೂ ಇಂದ ಬರುವಾಗ ಮ್ಯಾರೇಜ್ ಅನ್ನೋ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ನಲ್ಲಿ ಇನ್ಇಕ್ವಾಲಿಟೀಸ್ ಇನ್ಹೆರೆಂಟ್ಲಿ ಇರೋದ್ರಿಂದ ಅದನ್ನ ಅಡ್ರೆಸ್ ಮಾಡಕ್ಕೆ ಆಗಿಲ್ಲ. ಮತ್ತೆ ಬೇರೆ ತರದ ರಿಲೇಶನ್ಶಿಪ್ಸ್, ಮ್ಯಾರೇಜ್ ಇಂದ ಹೊರಗಡೆ ಇರೋ ರಿಲೇಶನ್ಶಿಪ್ಸ್ ನ ಹೇಗೆ ನಾವು ರೆಕಗ್ನೈಸ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋದನ್ನು ಈ ಪೆಟಿಷನ್ ಅಪ್ಲಿಕೇಶನ್ ಅಡ್ರೆಸ್ ಮಾಡಿಲ್ಲ. ಮತ್ತೆ ಈ SMA ಸ್ಪೆಷಲ್ ಮ್ಯಾರೇಜ್ ಆಕ್ಟ್ ಡೆಫಿನಿಷನ್ ಕೆಳಗಡೆ ಮಾತ್ರ ಬರ್ದೆ ಬೇರೆ ಎಲ್ಲಾ ರೈಟ್ಸ್ ನಮಗೆ ಒಂದು ಸ್ಪೆಕ್ಟ್ರಮ್ ಆಫ್ ರೈಟ್ಸ್, ಹೌಸಿಂಗ್, ಮತ್ತೆ ಬ್ಯಾಂಕ್ ಲೋನ್ಸ್, ಮತ್ತೆ ಮೆಡಿಕಲ್ ಡಿಸಿಷನ್ಸ್, ಈ ಎಲ್ಲಾ ರೈಟ್ಸ್ ನ ಹೇಗೆ ಆಕ್ಸೆಸ್ ಮಾಡೋದು ಪಾರ್ಟ್ನರ್ಶಿಪ್ಸ್ ಅಲ್ಲಿ SMA ಕೆಳಗಡೆ ಬರ್ದೆ ಅನ್ನೋದನ್ನು ನಾವು ಇಲ್ಲಿ ಅಡ್ರೆಸ್ ಮಾಡಕ್ ಆಗಿಲ್ಲ. ಮತ್ತೆ ಅವರು ಹೇಳಿದ್ರು ಅವ್ರಿಗೆ ಕೆಲವು ಜನ ಪರಿಚಯ ಇರೋರು ಇದ್ದಾರೆ, ಫ್ರೆಂಡ್ಸ್ ಇದ್ದಾರೆ, ಯಾರು ಜೊತೆಗಿದ್ದಾರೆ, ಬಟ್ ರೊಮ್ಯಾಂಟಿಕ್ ರಿಲೇಶನ್ಶಿಪ್ಸ್ ಅಲ್ಲಿ ಇಲ್ಲ. ಸೊ ಈ ತರ ರಿಲೇಶನ್ಶಿಪ್ಸ್ ನ ನಾವ್ ಹೇಗೆ ಅಡ್ರೆಸ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋದನ್ನು ಈ ಪಟಿಷನ್ ಆಗ್ಲಿ SMA ಆಗ್ಲಿ ಈ ಅಪ್ರೋಚ್ ಆಗ್ಲಿ ಅಡ್ರೆಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ಅವ್ರು ಮೂವ್ ಆನ್ ಆಗಿದ್ದು UCC ಯೂನಿವರ್ಸಲ್ ಸಿವಿಲ್ ಕೋಡ್ ಅಂತ ಇರೋ ಒಂದು ಕಾನ್ಸೆಪ್ಟ್ ಕೆಳಗಡೆ ಈ ಯೂನಿವರ್ಸಲ್ ಸಿವಿಲ್ ಕೋಡ್ ಅನ್ನೋದ್ರ ಕೆಳಗಡೆ ಈ ಮ್ಯಾರೇಜ್ ಅನ್ನೋ ಕ್ವಶನ್, ಈ ಸೇಮ್ ಸೆಕ್ಸ್ ರಿಲೇಶನ್ಶಿಪ್ ರೆಕಗ್ನಿಷನ್ ಅನ್ನೋ ಕ್ವಶನ್ ನಾವು ಹೇಗೆ ರೆಕಗ್ನೈಸ್ ಮಾಡ್ಬೋದು, ಮತ್ತೆ ಇದನ್ನ ಗ್ರೌಂಡ್ ಅಪ್ ಕೆಳಗಡೆ ಅಂದ್ರೆ ಸಮುದಾಯದ ಜೊತೆಗೆ ಕೆಲಸ ಮಾಡಿ ಮೇಲ್ಗಡೆ ತಗೊಂಡು ಹೋಗೋ ಒಂದು ಅಪ್ರೋಚ್ ಇದಕ್ಕೆ ಸೂಕ್ತ ಆಗುತ್ತೆ. ಆದ್ರೆ ಒಂದ್ ಪ್ರಾಬ್ಲಮ್ ಏನಂದ್ರೆ ಈ ತರ ಅಪ್ರೋಚ್ ಅಲ್ಲಿ ಬೇಗ ನಮಗೆ ಸೊಲ್ಯೂಷನ್ ಸಿಗಲ್ಲ. ತುಂಬಾ ವರ್ಷಗಳು, ತುಂಬಾ ಡಿಕೇಡ್ಸ್ ಆಗುತ್ತೆ ನಮ್ಗೆ ಈ ಗ್ರೌಂಡ್ ಅಪ್ ಅಪ್ರೋಚ್ ಅಲ್ಲಿ ತಗೊಂಡೋಗಿ ಸೊಲ್ಯೂಷನ್ ತಗೊಳ್ಳೋದು. ಮತ್ತೆ ಅವರು ಹೇಳಿದ್ರು ಇದನ್ನ ಈ ಸುಪ್ರೀಂ ಅನ್ನೋ ಜಡ್ಜ್ಮೆಂಟ್ ಫೇಲ್ಯೂರ್ ಅಂತ ಆಗ್ಲಿ, ಒಂದು ಡಿಸಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗ್ಲಿ ಅಂತ ನೋಡೋದ್ ಅಂತ ಅವ್ರಿಗೆ ಅನ್ನಿಸ್ತಾ ಇಲ್ಲ. ಬಟ್ ಇದು ಬೇರೆ ತರದ ರಿಲೇಶನ್ಶಿಪ್ಸ್ ನ, ಮ್ಯಾರೇಜ್ ಇಂದ ಹೊರಗಡೆ ಆಗಿರೋ ರಿಲೇಶನ್ಶಿಪ್ ನ ರೆಕಗ್ನೈಸ್ ಮಾಡಿಲ್ಲ. ಮತ್ತೆ ನಾವು UCC ಯೂನಿವರ್ಸಲ್ ಸಿವಿಲ್ ಕೋಡ್ ನ ಈ ತರ ಯೂನಿಫಾರ್ಮ್ ಸಿವಿಲ್ ಕೋಡ್ ನ ಈ ರಿಲೇಶನ್ಶಿಪ್ಸ್ ನ ರೆಕಗ್ನೈಸ್ ಮಾಡಕ್ಕೆ, ಪುಷ್ ಮಾಡಕ್ಕೆ ಒಂದು ಅವಕಾಶ ಇದೆ ನಮ್ಗೆ. ಬಟ್ ಅದ್ರಲ್ಲೂ ಪ್ರಾಬ್ಲಮ್ಸ್ ಇದೆ. ಗವರ್ಮೆಂಟ್ಸ್ ಇದ್ರ ಬಗ್ಗೆ ಮಾತಾಡಿದಾಗ ಅವರು ಈ ಅಪ್ರೋಚ್ ತಗೊಂಡು ಬರ್ತಾ ಇದಾರ, ಇಲ್ಲ ಇದು ಒಂದು ಯುಟೋಪಿಯನ್ ಅಂದ್ರೆ ಒಂದು ರಾಡಿಕಲ್ ಆಗಿರೋ ಒಂದು ರಿಲೇಶನ್ಶಿಪ್ಸ್ ನ ರೆಕಗ್ನೈಸ್ ಮಾಡೋ ಅಪ್ರೋಚ್ ತಗೊಂಡ್ ಬರ್ತಾ ಇದಾರ ಅಂತ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಮತ್ತೆ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಎಷ್ಟೊಂದು ರೀತಿಯಲ್ಲಿ ಒಂದು ಲಿಮಿಟಿಂಗ್, ಒಂದು ತಡೆಯನ್ನ ಹೊಂದಿದೆ. ಇದು ಡಿಸಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗುತ್ತೆ. ಮತ್ತೆ ಇದು ಯಾವ್ದೇ ತರದ ಕೋರ್ಟ್ ಇಲ್ಲ ಲಾ ಇಂದ ಬರೋ ಆನ್ಸರ್ ಆಗಿರೋದಿಲ್ಲ. ಈ ತರ ಮ್ಯಾರೇಜ್ ರೆಕಗ್ನಿಷನ್ ಆಗಿರ್ಬೋದು, ಇಲ್ಲ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ರೆಕಗ್ನಿಷನ್ ಆಗಿರ್ಬೋದು. ಬಟ್ ಜನರ ಕಡೆಯಿಂದ, ಮೂವ್ಮೆಂಟ್ಸ್ ಕಡೆಯಿಂದ ಬರೋ ಕೆಲ್ಸ. ಮತ್ತೆ ಸೆಕ್ಷನ್ 377 ಮ್ಯಾರೇಜ್ ಬಗ್ಗೆ ಅವರು ಮತ್ತೆ ಒಂದು ಕಂಪ್ಯಾರಿಸನ್ ಡ್ರಾ ಮಾಡ್ತಾರೆ. 377 ನಲ್ಲಿ ಹೇಗೆ ಒಂದು ಸ್ಟ್ರೇಟ್ ಫಾರ್ವರ್ಡ್ ಆಗಿರೋ ಒಂದು ಇನ್ಸೈಟ್ ಇತ್ತು, ಒಂದು ಪ್ರೊವಿಷನ್ ಇತ್ತು. ಬಟ್ ಇದ್ರಲ್ಲಿ ಮ್ಯಾರೇಜ್ ರೆಕಗ್ನಿಷನ್ ಅಂತ ಬಂದಾಗ ಅದ್ರಲ್ಲೂ ಅದೇ ತರ ಅಪ್ರೋಚ್ ತಗೊಂಡು ಕೋರ್ಟ್ ಹೋದಾಗ ನಮ್ಗೆ ಇದ್ರಲ್ಲಿ ಸರೋಗಸಿ ಅಂತ ಒಂದು ಕಾಂಪ್ಲಿಕೇಶನ್ಸ್ ಬರುತ್ತೆ. ಈ ಮ್ಯಾರೇಜ್ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ರೆಕಗ್ನೈಸ್ ಮಾಡುವಾಗ ಇದನ್ನ SMA ಕೆಳಗಡೆ ಅಡ್ರೆಸ್ ಮಾಡೋಕೆ ಸಾಧ್ಯ ಆಗಲ್ಲ. ಮತ್ತೆ ಇನ್ನು ಫೆಮಿನಿಸ್ಟ್ ವಾಯ್ಸ್ ಮತ್ತೆ ಫೆಮಿನಿಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಕಡೆ ಅಪ್ರೋಚ್ ಇಂದ ಬಂದಾಗ ಇದನ್ನ ಹೇಗೆ ನಾವು ಕ್ವಿಯರ್ ರೈಟ್ಸ್ ಗೆ ಟ್ರಾನ್ಸ್ಲೇಟ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋದನ್ನ ನೋಡ್ಬೇಕಾಗುತ್ತೆ. ಮತ್ತೆ ಅವರು ಮುಂದೆ BNS ಹೊಸ ಕ್ರಿಮಿನಲ್ ಲಾ BNS ಬಗ್ಗೆ ಮಾತಾಡ್ತಾರೆ. ಅದ್ರಲ್ಲಿ ಸೆಕ್ಷನ್ 377 ನ ಕಂಪ್ಲೀಟ್ ಆಗಿ ರಿಮೂವ್ ಮಾಡ್ತಾರೆ. ಮುಂಚೆ IPC ಅಲ್ಲಿ ಅದನ್ನ ಒಂದ್ ಪಾರ್ಟ್ ಮಾತ್ರ ತೆಗ್ದಿದ್ರು. ಅದ್ರಲ್ಲಿ ಕನ್ಸೆಂಟ್ ಇಲ್ದೆ ಅಂದ್ರೆ ಒಪ್ಪಿಗೆ ಇಲ್ದೆ ಇರೋ ಹರಾಸ್ಮೆಂಟ್ ಆರ್ ಒಪ್ಪಿಗೆ ಇಲ್ದೆ ಇರೋ ಒಂದು ಸೆಕ್ಷುವಲ್ ರಿಲೇಶನ್ಶಿಪ್ ನ ಇನ್ನ ಒಂದು ಕ್ರೈಮ್ ತರ ನೋಡ್ತಾ ಇದ್ರು IPC ಅಲ್ಲಿ. ಇವಾಗ ಹೊಸದಾಗಿ ಬಂದಿರೋ ಲಾಸ್ ನಲ್ಲಿ ಆ ಪ್ರಾವಿಷನ್ ಇಲ್ದೇ ಇರೋದ್ರಿಂದ ಇದು ಮಹಿಳೆಯರು ಅಲ್ದಿರೋ ಬೇರೆ ಎಲ್ಲಾ ಸಮುದಾಯದವರನ್ನ ಒಂದು ವಲ್ನರಬಲ್ ಸಿಚುಯೇಷನ್ ಅಲ್ಲಿ ಇಡುತ್ತೆ. ಮತ್ತೆ ಅಷ್ಟೇ. ಇನ್ ಮುಂದೆ ಹೋಗ್ತಾ ಇದನ್ನ ಹೇಗೆ ನಾವು ಮುಂದೆ ತಗೊಂಡು ಹೋಗ್ಬೇಕು, ಅದನ್ನ ನಾವು ಹೇಗೆ ಈ ರೈಟ್ಸ್ ನ ಆಕ್ಸೆಸ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋದನ್ನ.
For the translation. I just wanted to add just one small bit because that will help to go forward discussion, which is that as a part of the judgment, the direction also was to set up a high-powered committee to look at basically looking at what is the way to ensure rights of the LGBTQ community and what is the way of recognition of civil duty. The mandate of this high-powered committee is per se not set up in the judgment. The high-powered committee, that many of you may know, may not know, it has already been set up, but rather opaquely. The involvement in the community, what has happened is not something that's transparently known. We only know the members, who are the official members from the state of the government that are there. So that's where, along with the review petition being pending in the Supreme Court, also the other sort of way forward is in terms of about what kind of intervention do we want to do. So I'll stop here and also just show you all the booklets. Those who want to keep it at the end, this is the booklet. This is the official release of it, and there's also pamphlet in both English and Kannada. We don't have the booklet in Kannada, but we felt that it's better that we start with the pamphlet, get some response, and see what kind of material is needed specifically in Kannada. And so the pamphlets are already outside for those of you who want to take it. And we'll now proceed with the way forward discussion. Hold the booklet. Take a photo.
Everyone is whoever is in the frame holds.
Yeah.
No, it's okay. It's okay. Clap, no. Don't do this for the photo, auntie.
Sweet.
Thanks. Thank you. So yes, we'll proceed with the way forward discussion. There's a lot that you all have heard. So what are some of your thoughts in terms of way forward, looking at the question of marriage equality, looking at the question of the utopian world and the ideas that are here proposed? We'll try and do this bilingually. So those of you who know how to speak both Kannada and English, please speak in both Kannada and English. That's okay.
ನಿಮ್ಗೆ ಏನಾದ್ರು ಯೋಚನೆಗಳು ಇಲ್ಲ, ಐಡಿಯಾಸ್ ಇದ್ರೆ ಶೇರ್ ಮಾಡಿ.
Very happy to be here. I'm a law student, as I said, I studied international law. But I mean, this judgment here it's about a 400-page judgment, and one thing that is surprising is that it's a 5-0 decision, right? With respect to you cannot accommodate same-sex marriages, which I think, in my opinion, is correct, because it points out to how gendered the law can be. What are the limits? So I think where the Supreme Court heard is with respect to two areas. One is the right to union under 19C, and one is marriage as a fundamental. Now, my favorite decision of the law is Justice Paul's judgment. And it's a wonderful judgment. It's a very short judgment. Even though he does not recognize same-sex marriage, he says he recognizes civil unions. Now, he ends the judgment with a Bon Jovi song, It's My Life. And I really like that idea. But his idea is that once you recognize civil unions, you'll have to interpret statutes using the ideas. So using the idea of a civil, so that the statutes are not inconsistent with the Constitution, which means that once you recognize the right to a civil union under the Constitution, which is also a very sound interpretation, right? Because it started with Nalsa. Nalsa said under expression under the Constitution, also is gender expression. Now Chandrachud, Justice Chandrachud is expanding that scope to say right to union is not the traditional union that we do, it also civil. So I wanted to know your thoughts on that idea with regards to it, and also with regards to marriage as a fundamental. Now, when I read the judgment, I thought petitioners did a good job with respect to presenting their case. Right, what their case was mainly on the Hadia case, the Shafeen Jahan case from Kerala, which was a case about a Hindu woman who converted to Islam, who then was detained in her house by her family. The High Court of Kerala said that she has to go back to her family, and the Supreme Court said no, she has the right to choose, and that is an inherent right within Article 21. I thought right to marry would flow from that, would flow from the right to choose. That's what Aubergine felt the Supreme Court left, or Loving versus State of Virginia. I thought that would be the route that the petitioners would take, but unfortunately they took the SMA, which was wrong in that sense. But there is a future, right? There's a future about. I think the future would look like the Vishaka guidelines, where there is a clear ambiguity in the law, and where there is clear ambiguity, the courts are empowered to draft guidelines which would accommodate those things. And I think that is the way forward. That is how I look at it. The way forward is, I think, justice calls minority judgment. I think that is something later high courts can take. This is what I
We'll just take.
Yeah, so to add upon that, one of the justifications why they took the SMA route is because Menaka Goswami and Saurabh during the time of the argument, they especially said this one thing, that how they will have to keep knocking the doors of the court, and then how the whole marriage thing gives them a bouquet of rights. Say they have a marriage certificate, the whole word of marriage gives you, like, say, to claim other rights, like say death benefits of your partner, like say appointment on compassionate ground, and whatsoever, like that will
Pensions,
nomination and everything. Like, just because only the marriage certificate and then ration card, like as he said, like socio-economic, this thing also could be brought. Like they said that if you just recognize civil union, they will just have to keep coming to the court because all the other legislation they'll have to keep amending. You just can't keep forcing the government to do it. So it was more of a matter of convenience rather than like taking the strict view of, like, say, how SME has to be ready. So, and one more thing, just that when you said that had they declared under SMA that it would have been a full stop, rather than that, can we take it as it would have been a beginning step? Of course, SMA has its own problems. It can be challenged, like say the 30-day notice period. It could be a base starting point.
It would have been, that's all. If you, sorry,
Yeah, Trisha.
I think so. My question is more from the movement side, right? Like, we understand that decriminalization was a very sharp ask, which was easy to socialize within the community, and it was an ask in demand that a lot of people in the various spectrums of the LGBTQI space could come through. Now, from what we are hearing, I mean, apart from this judgment, there are two things. One is to socialize the idea of why marriage, because the community is divided even on that. And even in various sections of the community, it's very hard to organize in terms of the varied, like you mentioned, the complexity of something like this. And then the second thing that we're also hearing now from you is that what we also need to do socialization on, and also like building a kind of like an imagination of what would be in terms of various civil rights, which are not just in partnerships, but also as a community. There are also a lot of LGBTQI communities that live, share resources within more than two people, right? Like traditional communities that live around, right? Now, what kind of, like, what do we see the next step in terms of where do we begin? Because these are, sure, they could be one struggle, but there are many different things that we have to pick up on as the movement, as a community. And this is a long game. So at what point does the judgment offer itself to begin some kind of work on the ground up that leads to not the same route, which is, which ends up in a legal battle and ends up in like a petition again?
ಒಂದು ಸ್ವಲ್ಪ ಸಂಕ್ಷಿಪ್ತವಾಗಿ ಸ್ವಲ್ಪ ಅನುವಾದ ಮಾಡ್ಬೇಕು.
ಮೊದಲೇ ಹಕ್ಕು ವಿಚಾರ ಬರುವಾಗ ನಾನು ನ್ಯೂಟ್ರಲ್ ಇದ್ದೀನಿ ಆಸ್ ಎ ವರ್ಕಿಂಗ್ ಕ್ಲಾಸ್ ಕಮ್ಯುನಿಟಿ ಇನ್ ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್. ಆ ವಿಚಾರ ಬರುವಾಗ ಯಾಕಂದ್ರೆ ಆರ್ಟಿಒ ಹೇಳಿದಂಗೆ ನಾವು ಅರ್ಜೆಂಟ್ ಮಾಡ್ಬಾರ್ದಿತ್ತು ಅಂತ ಅದೊಂದು ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಅರ್ಥ ಆಗಿತ್ತು. ಒಂದು ಮದುವೆ ಹಕ್ಕನ್ನ ಯಾಕೆ ಕೇಳ್ತಾ ಇದ್ವಿ ಮತ್ತೆ ಯಾವ ವಿಷಯಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ವಿ ಅನ್ನೋದು ಸ್ಪಷ್ಟತೆ ನಮ್ಗಳಲ್ಲೇ ಇಲ್ಲ. LGBTQI+ ಬೇರೆ ಬೇರೆ ಐಡೆಂಟಿಟಿಗಳ ಬಗ್ಗೆ 2018 ಜಡ್ಜ್ಮೆಂಟ್ ಈಚೆಗೆ ಎಷ್ಟು ಜನ ನಾವು ಫೀಲ್ಡ್ ಅಲ್ಲಿ ಪಬ್ಲಿಕ್ ಗೆ ಓರಿಯೆಂಟೆಡ್ ಮಾಡ್ತಾ ಇದ್ವಿ. ಒಂದು ಅದನ್ನ ನಾವು ನಮ್ಮ ಐಡೆಂಟಿಟಿಗಳ ಬಗ್ಗೆ ಇನ್ 13 ಜಡ್ಜ್ಮೆಂಟ್ 377 ಇನ್ 14 ಆಲ್ಸೋ ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡಿದ್ರೆ ಅಲ್ಲಿ ಡಿವೈಡ್ ಆದ್ವಿ, ಬ್ರೇಕ್ ಆಯ್ತು. ಟ್ರಾನ್ಸ್ ಇಶ್ಯೂಗಳೇ ಸ್ವಲ್ಪ ಹೈಲೈಟ್ ಆಗ್ತಾ ಸ್ಟಾರ್ಟ್ ಆಯ್ತು. ಇನ್ನು ಟ್ರಾನ್ಸ್ ಇಶ್ಯೂಗಳೇ ಸೆಟ್ಲ್ ಆಗದ ವ್ಯವಸ್ಥೆಯಲ್ಲಿ ಇದೆ ದೇಶದಲ್ಲಿ. ಟ್ರಾನ್ಸ್ಜೆಂಡರ್ ಹಕ್ಕುಗಳು ಕೊಡ್ಬೇಕಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಮಾತಾಡುತ್ತೆ, ಪಾಲಿಸಿಗಳಿಲ್ಲ, ಕಾನೂನುಗಳಿಲ್ಲ, ಗೈಡ್ಲೈನ್ಗಳಿಲ್ಲ. ವ್ಯವಸ್ಥಿತವಾಗಿ ಒಂದು ಪ್ರೂವ್ ಮಾಡ್ಕೊಳಕ್ಕೆ ಕೈಯಲ್ಲಿ ಏನು ಇಲ್ಲದೆ ಅಂತ ವ್ಯವಸ್ಥೆಯಲ್ಲಿ ನಾವು ಬದುಕ್ತಾ ಇದೀವಿ. ಇನ್ನ ಸೆಕ್ಸುವಾಲಿಟಿ ಇಶ್ಯೂಗಳನ್ನ ನಾವು ಎಷ್ಟರ ಮಟ್ಟಿಗೆ ಫೀಲ್ಡ್ ಅಲ್ಲಿ ಅರ್ಥ ಮಾಡಿಸಿದ್ವಿ ಜನಕ್ಕೆ. ಇಲ್ಲಿ ನಾವು ಹೇಳ್ಬೋದು, ನಾನು ಇದಕ್ಕೆ ವಿರೋಧನೂ ಇಲ್ಲ ಪರಾನೂ ಇಲ್ಲ ಸದ್ಯದ ಮಟ್ಟಲ್ಲಿ. ಯಾಕಂದ್ರೆ ಒಂದ್ ಸಮುದಾಯ ಕೇಳ್ತಾ ಇದೆ ಅಂದ್ರೆ ರೆಸ್ಪೆಕ್ಟ್ ಮಾಡ್ತೇನೆ, ಆದ್ರೆ ಅದು ಆಗು ಹೋಗುಗಳನ್ನು ನಾವು ಚರ್ಚೆ ನೋಡ್ಬೇಕಾಗುತ್ತೆ. ಪೊಲಿಟಿಕಲಿ ನಮ್ ಬಗ್ಗೆ ಮಾತಾಡೋರು ಯಾರಿಲ್ಲ, ಮಾತಾಡಂಗೂ ಇಲ್ಲ. LGBT ಮತ್ತೆ ಸೆಕ್ಸುವಾಲಿಟಿ ಇಶ್ಯೂನ ಮಾತಾಡಂಗಿಲ್ಲ. ಟ್ರಾನ್ಸ್ ಇಶ್ಯೂ ಅಲ್ಲಿ ಓನ್ಲಿ ಟ್ರಾನ್ಸ್ ವುಮೆನ್, ಪಾಪ, ದೇವರು, ಆ ರೀತಿ ಕಾನ್ಸೆಪ್ಟ್ ಅಲ್ಲಿ ಆಲ್ ಓವರ್ ಪಾರ್ಟಿ, ಕಾಂಗ್ರೆಸ್, ಬಿಜೆಪಿ, JDS ಎಲ್ಲ ಪಾರ್ಟಿ. ಸೆಕ್ಸುವಾಲಿಟಿ ಇಶ್ಯೂನು ಸಹ ಈ ಸರ್ಕಾರನೇ ಮುಟ್ಟಲ್ಲ, ಟಚ್ ಮಾಡೋದು ಪ್ರೋಗ್ರೆಸಿವ್ ಪಾರ್ಟಿ. ನಾವು ಎಷ್ಟರ ಮಟ್ಟಿಗೆ ಸೋಷಿಯಲ್ ಮೂವ್ಮೆಂಟ್ ಗಳಲ್ಲಿ ವಿಮೆನ್ಸ್ ಗ್ರೂಪ್ ಇರ್ಬೋದು, ದಲಿತ್ ಗ್ರೂಪ್ಸ್ ಇರ್ಬೋದು, ಬೇರೆ ಬೇರೆ ಗ್ರೂಪ್ಗಳಲ್ಲಿ ಈ ಐಡೆಂಟಿಟಿಗಳ ಬಗ್ಗೆ ಮಾತಾಡ್ತಾ ಇದ್ದೀವಿ. ಲೆಸ್ಬಿಯನ್ ಅಂದ್ರೆ ಯಾರು? ಓನ್ಲಿ ನಾವು ಅದನ್ನ ನೋಡ್ತಾ ಇರೋದು ಸೆಕ್ಸುವಲಿ ದೃಷ್ಟಿಕೋನದಲ್ಲಿ, ಸೆಕ್ಸ್ ದೃಷ್ಟಿಕೋನದಲ್ಲಿ ನೋಡ್ತಾ ಇದ್ವಿ. ಪ್ರೀತಿ ಅಂದ್ರೆ ಅವ್ರು ಸೆಕ್ಸ್ ಮಾಡಕ್ಕೆ ಕಪಲ್ಸ್ ಆಗ್ತಾ ಇರ್ತಾರೆ. ಅಲ್ಲ, ಹೇಗೆ ಗಂಡ ಹೆಂಡತಿ 24 hours ಸೆಕ್ಸ್ ಮಾಡಲ್ಲ ಗಂಡ ಹೆಂಡತಿ. ಇಲ್ಲ, ಅದನ್ನ ಮುಕ್ತವಾಗಿ ಮಾತಾಡ್ಬೇಕಾಗ್ತಾ ಇದೆ. ನಾವು ಒಂದು ಸಂಬಂಧ, ಒಟ್ಟಿಗೆ ಇರೋ ಸಂಬಂಧ, ಪರಸ್ಪರ ನಾವು ಅವ್ರ ಜೊತೆಗೆ ನೋವುಗಳನ್ನ ಹಂಚ್ಕೊಳ್ಳೋ ಸಂಬಂಧ, ಮತ್ತೆ ಇಬ್ಬರು ಪರಸ್ಪರ ಒಂದು ಜವಾಬ್ದಾರಿಯಾಗಿ ಯಾವ ರೀತಿ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಮಾಡ್ಕೊಂಡು ನಮ್ ಲೈಫ್ ಅನ್ನ ಲೀಡ್ ಮಾಡ್ತೀವಿ ಅನ್ನೋ ಸಂಬಂಧ. ಮತ್ತೆ ಆ ರೀತಿ ಕೇಸ್ಗಳಾದಾಗ ಆ ರೀತಿ ನಾವು ಕೇಸ್ ಸ್ಟಡಿಗಳನ್ನ ಎಷ್ಟು ಪ್ರೆಸೆಂಟ್ ಮಾಡಿದೀವಿ ಕೋರ್ಟಲ್ಲಿ. ಈಗ ಮದುವೆದೊಂದು ಸರ್ಟಿಫಿಕೇಟ್ ತಗೊಂಡು ನಾವು ಅದನ್ನ ಪ್ರೂವ್ ಮಾಡಕ್ಕೆ ಅಂತಲ್ಲ, ಅದರಿಂದ ಸರ್ಟಿಫಿಕೇಟ್ ಬೇಕಂದ್ರೆ ಯಾಕೆ ಬೇಕಾಗಿದೆ ಅನ್ನೋದು ಒಂದು ಸ್ಪಷ್ಟತೆ ನಮ್ಗಳಲ್ಲೇನೆ ಯಾವ ರೀತಿ ನೋಡ್ತೀವಿ ಅಂತೇಳಿ ನಾವ್ ಅದನ್ನ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆತರ ಪಟ್ಟಿದ್ವಿ ಅನ್ಸುತ್ತೆ. ಇದನ್ನ ಒಂದು ವ್ಯವಸ್ಥಿತವಾಗಿ ಚರ್ಚೆ ಮತ್ತೆ ಅರ್ಥ ಮಾಡಿಸ್ಬೇಕಿತ್ತು. ಸ್ಟೆಪ್ ಹೋಗಿದ್ ಒಳ್ಳೇದೇ ಒಂದ್ ಕಡೆ. ಅದಾದ್ರೂ ಅಟ್ಲೀಸ್ಟ್ ಜಸ್ಟಿಸ್ ಗಳಲ್ಲಿ ಒಂದು ಅರ್ಥ. ಈಗ ಚಂದ್ರಚೂಡ ಯಾಕೆ ಆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಬಂತಂದ್ರೆ ಅದು ಕೊಡ್ಲೇಬೇಕಾದ ಪರಿಸ್ಥಿತಿ ಇದೆ. ಆ ಸೀಟಲ್ಲಿ ಕೊಟ್ಟ ತಕ್ಷಣ ಬೇರೆ ಬೇರೆ ವ್ಯವಸ್ಥೆಗಳಿದಾವೆ. ಅದನ್ನ ಯಾವ ದೃಷ್ಟಿಕೋನದಲ್ಲಿ ನೋಡ್ತೀವಿ. ಮತ್ತೆ ನಾವು ಈ 1 ವರ್ಷ ಆಯ್ತು ಜಡ್ಜ್ಮೆಂಟ್ ಬಂದು, ಎಷ್ಟಾದ ಮಟ್ಟಿಗೆ ಮದುವೆ ಹಕ್ಕುಗಳ ಬಗ್ಗೆ ನಾವುಗಳು ಮಾತಾಡ್ತಾ ಇದ್ವಿ. ನಾವುಗಳು ಎಷ್ಟರ ಮಟ್ಟಿಗೆ 1 ವರ್ಷದಲ್ಲಿ ಮಾತಾಡಿದೀವಿ. ಸ್ಮಾಲ್ ಗ್ರೂಪ್ 10 ಮೆಂಬರ್ಸ್ ಇರ್ಬೋದು, 1000 ಜನ ಇರ್ಬೋದು. ಮದ್ವೆ ಹಕ್ಕು ಯಾಕೆ ಬೇಕಂತಂದ್ರೆ ಓನ್ಲಿ ಸೆಕ್ಸ್ ಕಾನ್ಸೆಪ್ಟ್ ಗೆ ಬೇಕಾಗಿಲ್ಲ ನಮ್ಗೆ ಹಕ್ಕು. ನಮ್ಗೆ ಈ ಒಂದು ನೀಡ್ಗಳಿದಾವೆ. ನಮಗೂ ಮಕ್ಕಳನ್ನ ದತ್ತು ತಗೊಳ್ಳೋ ಆಸೆ ಇದೆ, ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಪಾಲ್ ಬೇಕನ್ನೋ ಆಸೆ ಇದೆ. ಈ ವಿಚಾರಗಳನ್ನ ನಾವು ಯಾವ ರೀತಿ ತಗೊಂಡು ಹೋಗ್ತೀವಿ. ಮತ್ತೆ ಪ್ರೆಸೆಂಟ್ ಕಾಂಗ್ರೆಸ್ ಗೌರ್ಮೆಂಟ್ ಇರೋದ್ರಿಂದ ಇಲ್ಲಿ ಆ ಇಶ್ಯೂಗಳನ್ನ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಬೋದು, ಕರ್ನಾಟಕದಲ್ಲಿ ಪ್ರಾರಂಭ ಮಾಡ್ಬೋದು. ಅವರು ಮುಂದೆ ಒಪ್ಕೊಂತಾರೆ, ಹಿಂದೆ ಬೈತಾರೆ, ನೋ ಪ್ರಾಬ್ಲಮ್. ಅಟ್ಲೀಸ್ಟ್ ಚರ್ಚೆ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ. ಈ ಸರ್ಕಾರನ ಒಪ್ಕೊಳ್ಳಲ್ಲ ಸೆಕ್ಸುವಾಲಿಟಿ ರೈಟ್ಸ್ ಅನ್ನ ಹಿಡನ್ ಅಜೆಂಡಾ ಇಂಟರ್ನಲ್ಲಿ ಅದನ್ನ ಅವ್ರ ಮುನ್ನೆಲೆಗೆ ತರಲ್ಲ. ಅದನ್ನ ನಾವ್ ಯಾವ ರೀತಿ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತೀವಿ, ಸೋಷಿಯಲ್ ಮೂವ್ಮೆಂಟ್ ಗಳಲ್ಲಿ ಯಾವ ರೀತಿ ತಗೊಂಡು ಹೋಗ್ತೀವಿ, ವಿಮೆನ್ಸ್ ಗ್ರೂಪ್ ಗಳಲ್ಲಿ ಅಷ್ಟು ಇನ್ನೂ ಕ್ಲಾರಿಟಿ ಇಲ್ಲ. ಇನ್ನು ಟ್ರಾನ್ಸ್ ಬಗ್ಗೆ ವಿಮೆನ್ಸ್ ಗ್ರೂಪ್ ಗಳು ಮೆಜಾರಿಟಿ ಅರ್ಥ ಮಾಡ್ಕೊಂಡಿಲ್ಲ. ಟ್ರಾನ್ಸ್ ವಿಮೆನ್ ಅಂದ್ರೆ ಐಡೆಂಟಿಟಿ ಈಜಿಯಾಗಿ ಆಗುತ್ತೆ. ಟ್ರಾನ್ಸ್ ಮ್ಯಾನ್ ಇದ್ದಾರೆ, ಪ್ಯಾಂಟ್ ಶರ್ಟ್ ಅಲ್ಲಿ ಇರೋರು ಇದ್ದಾರೆ, ಜೋಗಪ್ಪ ಇದ್ದಾರೆ, ಬೇರೆ ಬೇರೆ ಐಡೆಂಟಿಟಿಗಳು ಹಲವಾರು ಐಡೆಂಟಿಟಿ ಟ್ರಾನ್ಸ್ ಅಲ್ಲೇ ಇದೆ. LGBT ಅಲ್ಲಿ ದೊಡ್ಡ ಅಂಬ್ರೆಲಾ, ಆ ಅಂಬ್ರೆಲಾ ಬಗ್ಗೆ ಯಾವ ರೀತಿ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಮಾಡ್ಕೊಳ್ತೀವಿ ಅನ್ನೋದು ಫಸ್ಟ್ ಇಂಟರ್ನಲ್ಲಿ ಕಮ್ಯುನಿಟಿ ಓರಿಯಂಟೇಶನ್, ನೆಕ್ಸ್ಟ್ ಪಬ್ಲಿಕ್ ಓರಿಯಂಟೇಶನ್, ಆಮೇಲೆ ಸರ್ಕಾರಕ್ಕೆ ಪ್ರಚಾರ. ಈ ಮೂರು ನಾವು ಹೋದ್ರೆ ನೆಕ್ಸ್ಟ್ ಹೋಗ್ಬೋದು. ಇಷ್ಟು ಅಭಿಪ್ರಾಯ.
ಅದು ಮೊನ್ನೆ ಒಂದು ಸೆಲೆಕ್ಟ್ ಆಗಿತ್ತು ಡಿವೋಯ್ಸಿ SJ ಇದು, ಅದ್ರಲ್ಲಿ ನಾಮಿನಿ ಮಾಡ್ಬೋದು, ಮತ್ತೆ ಅವ್ರಿಗೂ ಬ್ಯಾಂಕ್ ಖಾತೆಗಳಲ್ಲಿ
RBI.
ಕೊಡ್ಬೋದು. ಸೊ ಇದಕ್ಕೂ ಅದಕ್ಕೂ ಏನು ಕನೆಕ್ಷನ್ಸ್ ಇದೆ? ಸೊ ಆತರ ಬಿಟ್ಟು ಕೂಡ ಮತ್ತೆ ಯಾಕೆ ಇದು ಮ್ಯಾರೇಜ್ ನ ಒಪ್ಕೊಳಕ್ಕೆ ಅವರು ಪರಿಸ್ಥಿತಿಯಲ್ಲಿ, ಅಂದ್ರೆ ಅದನ್ನ ಕೊಟ್ರು ನಾಮಿನಿ ಮಾಡ್ಕೊಬಹುದು ಪಾರ್ಟ್ನರ್ಸ್ ಅಂತ ಹೇಳಿ ಕೊಟ್ರು, ಅದ್ರಲ್ಲಿ LGBTQI ಅಂತ ಇದೆ. ಸೊ ಇರುವಾಗ ಎಲ್ಲರೂ ಬರ್ತಾರೆ. ಸೊ ನಾಮಿನಿ ಅಂದ್ರೆ ಗೇ ಕಪಲ್ ಯಾರು ಇರ್ತಾರೆ ಅವ್ರ ಪಾರ್ಟ್ನರ್ಸ್ ಜೊತೆ ಅವ್ರು ನಾಮಿನಿ ಮಾಡ್ಬೋದು, ಲೆಸ್ಬಿಯನ್ ಕಪಲ್ ಯಾರು ಇರ್ತಾರೆ ಅವ್ರ ನಾಮಿನಿ ಮಾಡ್ಬೋದು. ಸೊ ಆತರ ಅವರೇ ಹೇಳ್ತಾರೆ, ಮತ್ತೆ ಅದನ್ನೇ ಮ್ಯಾರೇಜ್ ನ ಲೀಗಲ್ ಆಗಿ ಮಾಡಕ್ ಯಾಕೆ ರೆಡಿ ಇಲ್ಲ?
ಸಂಸ್ಕೃತಿ ಈ ದೇಶದಲ್ಲಿ ಹಿಂದುತ್ವವಾದ ಮತ್ತೆ RSS ಅಜೆಂಡಾ ಇದೆ. ಅದಿರೋವರೆಗೂ ಇದು ಕೊಡಕ್ಕೆ ಮುಂದೆ ಬರಲ್ಲ ಅವರು. ಕ್ರಿಶ್ಚಿಯಾನಿಟಿಗೆ ಆಡ್ ಮಾಡ್ತಾ ಹೋಗ್ತೀನಿ. ಅವರು ಟ್ರಾನ್ಸ್ ಹಕ್ಕುಗಳನ್ನ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದ್ರು, ಇವ್ರು ನಾವು ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು. ಕೋವಿಡ್ ಸಂದರ್ಭದಲ್ಲಿ ಅವ್ರಿಗೆ ಮನಸ್ಸಿಗೆ ಯಾವ ರೀತಿ ಬೇಕೋ ಆ ರೀತಿ ಕಾನೂನುಗಳನ್ನ ತಂದ್ರು. ಸರ್ಕಾರಕ್ಕೆ ಇದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ನಾವು ಕಾನೂನು ತಂದಿದ್ವಿ ನೋಡಿ. ಆದ್ರೆ ಆ ಕಾನೂನು ಎಷ್ಟರ ಮಟ್ಟಿಗೆ ಟ್ರಾನ್ಸ್ ಸಮುದಾಯದ ಹಕ್ಕುಗಳನ್ನ ರಕ್ಷಣೆ ಮಾಡುತ್ತೆ ಅನ್ನೋದು ಒಂದು ಪ್ರಶ್ನೆ ಆಗಿದೆ. ಮತ್ತೆ ನಮ್ಮ ಮೇಲೆ ವೈಲೆನ್ಸ್ ಆದಾಗ ಯಾವ ರೀತಿ ಶಿಕ್ಷೆ ಇದೆ? 1 ವರ್ಷ 2 ವರ್ಷ 2 ವರ್ಷ ಜೈಲ್ನಾಗಿರೋನು ನನ್ ಕೊಲೆನು ಮಾಡ್ಬೋದು. ಈಗ 302 ಹಾಕಿದ್ರೆ ಆಲ್ಮೋಸ್ಟ್ 10-14 ಇಯರ್ಸ್ ಶಿಕ್ಷೆ ಇದ್ದವ್ರೆ 3 months ಅಲ್ಲಿ ಹೊರಗಡೆ ಬರ್ತಾರೆ, ಬೇಲಲ್ಲಿ ಆರಾಮ್ ಕೋರ್ಟಿಗೆ ಹೋಗ್ತಾ ಹ್ಯಾಪಿ ಆಗಿರ್ತಾರೆ. ಇನ್ 2 years ಪನಿಷಬಲ್ ಇರುವಂತವ್ರು ಆಮೇಲೆ ಎಷ್ಟು ದಿನ ವೈಲೆನ್ಸ್ ಆಗ್ತದೆ. ಮತ್ತೆ ಒಂದ್ ಕಡೆ ಅವ್ರು ಹೇಳ್ತಾರೆ ಬೇರೆ ಬೇರೆ ಸೌಲಭ್ಯ ಕೊಡ್ತಾ ಇದ್ವಿ, ಯಾಕೆ ಮದ್ವೆ ಹಾಕ್ಬೇಕು ಅಂತ ಕೇಳ್ತಾರೆ. ನಿಮ್ಗೆ ನಾಮಿನಿ ಕೊಡ್ತಾ ಇದ್ದೀವಿ, ನಿಮ್ಗೆ ಬದುಕಕ್ಕೆ ಬಿಡ್ತಿದ್ವಿ ಈ ದೇಶದಲ್ಲಿ, ಮತ್ತೆ ಬೇರೆ ಮದ್ವೆ ಯಾಕೆ ಮದ್ವೆ ಆಗಿ ಏನಾದ್ರು ಪ್ರೂವ್ ಮಾಡ್ಬೇಕಂತ ಕೇಳ್ತಾರೆ. ನಾವ್ ಯಾಕೆ ಮದ್ವೆ ಬೇಕನ್ನೋದು ನಾವ್ ತಯಾರಿ. ಯಾಕೆ ಮದ್ವೆ ಬೇಕು, ಮತ್ತೆ ಮದ್ವೆ ಸರ್ಟಿಫಿಕೇಟ್. ಮದ್ವೆ ಅಂದ್ರೆ ನಾವು ಆಲ್ರೆಡಿ ಪಾರ್ಟ್ನರ್ಸ್ ಗಳು ಇದಾರೆ, ಆಲ್ರೆಡಿ ಪಾರ್ಟ್ನರ್ಸ್ ಇದ್ದಾರೆ, ನಾವು ಅವ್ರ ಜೊತೆಗೆ ಇದ್ದೀವಿ, ಜೊತೆಗೆ ಜೀವನ ಮಾಡ್ತಾ ಇದ್ವಿ. ಆದ್ರೆ ಆ ಸರ್ಟಿಫಿಕೇಟ್ ಯಾಕೆ ಬೇಕಂದ್ರೆ ಕಾನೂನಾತ್ಮಕವಾಗಿ ನಂಗೆ ಈ ದೇಶದಲ್ಲಿ ಸಂವಿಧಾನ ಇದೆ, ಮಾನ್ಯತೆ ಸಿಗೋಕ್ಕೋಸ್ಕರನೇ ಕೇಳ್ತಾ ಇರೋದು. ನಾವು ಸಂವಿಧಾನನಲ್ಲಿ ಟ್ಯಾಗ್ ಮಾಡ್ಲೇಬೇಕಾಗುತ್ತೆ. ಅದನ್ನ ನಾವು ಯಾವ ರೀತಿ ತಗೊಂಡು ಹೋಗ್ತೀವಿ.
Want to respond to?
Yeah, no, I just want to, I think the idea that you can plug this with some kind of Vishaka guidelines type thing is, I think the issue is much just far more complicated than that. Because in Vishaka, you are looking at one particular space of employment and a particular type of harassment in that particular workplace, and it was something that was a little bit more controllable by a set of guidelines. So I think that I really like Justice Kaul's articulation of the civil union. I still think it's going to have to be a legislation. I think it's going to have to be a legislation. It is going to have to be a legislation that finds a way of speaking to existing other legislations like your Hindu Succession Act, Indian Succession Act, your CARA adoption guidelines, your surrogacy laws, your artificial reproductive technology statutes. It has to speak. You have to find a way of reading this civil union legislation. Has to find a way of speaking to all of these statutes, but that's the reason why I think it has to come in the form of a legislation. I don't think there is any other way around it. I do think it's something that has to be legislated. Why I think that if they had given you marriage, that's all they would have given you, is because every time you raised a question of I'm a non-married person in a relationship, they would have said, look, if you're not married, please go and get married. If you look at, this has been the response to single women's articulation as well, right? It is very difficult. We have a domestic violence statute that is supposed to recognize relationships in the nature of marriage, which are not marriage, etc. But those are extremely difficult statutes to operationalize. The far easier statutes to operationalize are the ones where you fairly fall under the category of being married. So had they given SMA as your solution, that would have been the end of the road in terms of, I think, in terms of articulating any other form of living. This is my sense of it. I think it's very important to grant marriage. Please, I have no, I think you have to be able to squarely say that people require a legitimacy of their relationship. The question is, in what form should that legitimacy come? My question has always been, is the demand from the community the legitimacy under the Special Marriage Act with the fullness of understanding of how the Special Marriage Act operates? That's the question that I have. I have no doubts about the fact that there needs to be legitimacy completely. I think many things need to come before that. I think bank loans, this nomination, ration cards, adoption and surrogacy, I fear will only come when some kind of civil union is recognized through a partnership is recognized. Without that, I fear, because even now a non-married heterosexual couple cannot adopt. It's only one of them who can adopt a child, right? It's not, they can't adopt as a couple. So I feel that the idea of marriage is too deeply entrenched already into the surrogacy and adoption statute. So I don't think it's going to be a very hard articulation to make outside of recognition of some kind of partnership. But I do think that I have no doubts that there needs to be a comprehensive legislation that addresses the range of people who wish to enter into relationships of a particular kind. And that should be available to any two people, whether they are heterosexual, whether they are not, whatever their combination of their relationship. I do think that needs to be covered. I think it needs to be covered in a very comprehensive legislation that, like I said, that speaks to all of these various other complexities that we have. Yeah, I have nothing.
I think thanks for putting it the way you put it, which is when we think of the superior decision, right? It's a nice articulation to say that, what it does is it takes forward the idea of association. The idea of association to the idea of intimate association. ಅದು ಅವ್ರು ಏನ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ 19(1)C ಕೆಳಗಡೆ ಸಂಘಟಿಸುವ ಹಕ್ಕಿರುತ್ತೆ. ಆದ್ರೆ ಇಷ್ಟುವರೆಗೆ ಸಂಘಟಿಸುವ ಹಕ್ಕಂದ್ರೆ ಬರೀ ಸಂಘಟನೆಗೆ. ಆದ್ರೆ ಇಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ, ಸಂಘಟನೆ ಅಂದ್ರೆ ಇಬ್ಬರು ಒಂದು ಸಂಬಂಧದಲ್ಲಿದ್ರೆ ಅದು ಕೂಡ ಸಂಘಟನೆ, ಅದು ಕೂಡ ಹಕ್ಕಿರ್ಬೇಕು ಅಂತ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಚಂದ್ರಚೂಡ್ ಹೇಳ್ತಾರೆ. ಅದು ತುಂಬಾ ಒಳ್ಳೆಯ ಆರ್ಟಿಕ್ಯುಲೇಷನ್ ಹೇಳ್ತಾರೆ. ಅದು ನಮ್ಮ ನಲ್ಸಾ ತೀರ್ಪಿನಲ್ಲಿ ಕೂಡ 19(1)A ಫ್ರೀಡಮ್ ಆಫ್ ಸ್ಪೀಚ್ ಅಂಡ್ ಎಕ್ಸ್ಪ್ರೆಷನ್, ವೈಯಕ್ತಿಕ ಸ್ವಾತಂತ್ರ್ಯ ಏನು, ನಮ್ಮ ಲಿಂಗವನ್ನ ಹೇಗೆ ನಮ್ಮ ದೇಹದಲ್ಲಿ ಹೇಗೆ ವ್ಯಕ್ತಪಡಿಸ್ತೀವೋ ಅದು ಕೂಡ ವೈಯಕ್ತಿಕ ಸ್ವಾತಂತ್ರ್ಯದ ಒಂದು ಭಾಗ. ಸರಿ, 19(1)A ಹೇಗೆ ಅದನ್ನ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿದ್ದಾರೆ, ಅದೇ ತರ 19(1)C ಇಲ್ಲಿ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿದ್ದಾರೆ. ಅದು ತುಂಬಾ ಒಳ್ಳೆ ಬೆಳವಣಿಗೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. I think that's a great point. The question though, I can't, it's a great point and leave it at that. The question you're asking
Fundamental right
is, that's the second question. The first question on the intimate association, my reading, I didn't again see you're right. The 500 page, you interpreted one way, I interpreted one way. That's always the problem. I read it. What Justice Chandrachud is saying. He's saying that, see, an intimate association results in certain rights. And see, for which he says you have to consider a high court committee. The high court committee tasked with the task, right, of saying what are the contours of the rights to explore the intimate association. That's the way he sees it. Right? So I think Again, that's why I was so, the Justice Butts said made no sense to me. He said, oh, you can't mandate the creation of an institution. The institution not being mandated. All Justice Chandrachud saying is given a very weak remedy. Saying high part committee be constituted when you choose to constitute it. The committee will decide on the question of what are the rights of an intimate association. Nothing beyond that. And that Justice Butt dissents. So that's why I read the question of of the intimate association and the rights to flow from it. On the marriage as a fundamental right, ಅದು ತಿರುಗಿ ಎರಡನೇ ಅಂಶ ಈ ಮದುವೆ ಒಂದು ಮೂಲಭೂತ ಹಕ್ಕ ಇಲ್ವಾ ಅಂತ ಪ್ರಶ್ನೆ. ಅದು ನಮ್ಮ ಎಲ್ಲಾ 5 ನ್ಯಾಯಾಧೀಶರು ಹೇಳ್ತಾರೆ ಇಲ್ಲ ಅದು ಮೂಲಭೂತ ಹಕ್ಕ ಅಲ್ಲ. So why did that happen? Right? My own reading and my guess would be, my speculative guess would be that you're right. You read Adya and every previous judgment of Justice Chandrachud, you will say he has only one path left to say marriage is fundamental right. You recognize everything is fundamental right. What's the problem in recognizing marriage as fundamental right? There's no problem. The way I see it, no legal flow, but he does. Right? My reading would be this, right? I mean, I would say that he says, if you see the 5-3 kind of a thing, he's saying, I'll go with everybody on the question of marriage is not a fundamental right. And of course, there's a problem with that. Problem with that is, of course, love jihad laws, all of that. It's a very difficult challenge constitutionally because you think marriage is not a fundamental right. But he says, I'm hoping that I'll get my 3 judges on the question of intimate association. And what seems to have happened is he fell short on that. Justice Butt, who should have been with him, is not with him. And Justice Chandrachud's critique of Butt is very strong, and rightly so. He says, you make all these great things about yes, the LGBT community should have rights, yes, the discriminated against, and finally, without a right, there's no remedy. Without, you've given no remedy at all. What does that mean? And he's right. I think the criticism is very sharp and very strong and very right, saying that he's befuddled at Justice Butt not being with him. So that's the big mystery. I think why did Justice Butt leave this question of and leave this question of the possible majority, right? So that I would say it's a more of a political, reason why he doesn't say marriage is a fundamental right, why he goes with the majority. That'll be my reading. Because logically it makes no sense. And even if you read Justice Chandrachud's opinion, he's like every other part, which is a part of the right to marry, the right to dignity, the right to choice, right to companionship, right to love, all of that is right. Only marriage I can't say the fundamental. So it makes absolutely no sense. Absolutely no sense. So I'm with you on the befuddlement on that particular question. On the SMA as a beginning step, I'm inclined to agree. I'm saying that yes. I mean, we see this again in many ways, right? I mean, Ati is taking a certain kind of a line, and when I can see everybody's heart sinks, just 20 years you battle and you make it something. We're like, we don't have 20 years to waste. We're 50 years old already. We will die by the time. That point aside, the successful patient. So I agree. I think because the point which I think why again this gets to the question of why we call it marriage equality. We call it that because there's also it's not marriage in a narrow sense semi alone. Right? It's a way in which you're trying to make a broader case, right? Of what is the dignity of a relationship between two men or two women? What is the question of acceptance, social acceptance of that form of relationality? So all of that is there embedded in the marriage. It's not just a technical, narrow legal point alone. Right? There's a wider dimension of a recognition of dignity and the question of life in a broader sense. I think. So that's why I would be inclined to go with the line that though I completely share the critique of the petition being filed. Once it's filed, I'm saying you must recognize some rights. You can't not say anything at all. That's super important. Then the fourth question of Disha's point of marriage and the community being divided. Yes, it is true. The community is divided on what they want out of the marriage question. But again, the remedy is a very narrow one. What you're saying, as we said again and again, marriage equality. This is where again the slight divergence, saying that there is the burden or there is the responsibility to say how do you open out a path to different forms of relationality. At the same time, if two people want to enter that institution, they're totally entitled to enter the institution from the point of Article 2. Equal protection of the laws. If two heterosexual people can be in a relationship, two gay people or two queer people can totally entitled to be in it, whatever the demerits of the institution. You have that right. And nobody can say you don't have it. That's the Article 14. I would say on that point. That's the question. Then Mallu ಹೇಳಿದ ಅಂಶ ನಿಮ್ ಜೊತೆಲೆ ಒಪ್ಪಿಗೆ ಇರುತ್ತೆ ಖಂಡಿತವಾಗಿ ಇದ್ರ ಬಗ್ಗೆ ಗ್ರೌಂಡ್ ಲೆವೆಲ್ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ಬೇಕು, ಜನರಿಗೆ ಇದನ್ನು ಇಶ್ಯೂನ ತಲುಪಬೇಕಾಗುತ್ತೆ. ಮತ್ತು ಸಮುದಾಯದಲ್ಲಿ ಇನ್ನೂ ಸ್ವಲ್ಪ ಚರ್ಚೆ ಆಗ್ಬೇಕು, ಇದು ಯಾವ ತರ ನಾವು ಮುಂದೆ ತಗೊಂಡು ಹೋಗ್ಬೇಕು ಅಂತ ಅದ್ರ ಬಗ್ಗೆ ನಾವು ಖಂಡಿತವಾಗಿ ಚರ್ಚೆ ಆಗ್ಬೇಕು. ಕ್ರಿಸ್ಟಿ ಅವ್ರ ಪ್ರಶ್ನೆ, ಅದು ಈ ಕಮಿಟಿ, ಈ ಹೈಪಾರ್ಟ್ ಕಮಿಟಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡಿದ್ರು. ಈ ಕಮಿಟಿ ಒಂದು ರೆಕಮೆಂಡೇಶನ್ ಇತ್ತು, ಇದು ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ಸ್ ಓಪನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಇಬ್ಬರಿಗೆ ಒಂದು ಹಕ್ಕಿರತ್ತೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಅಷ್ಟ್ ಹೇಳ್ತಾರೆ. ಅದರಿಂದ ಇನ್ನು ಮುಂದೆ ಹೋಗ್ಬೇಕು. ಸೊ ಅದು ನೀವು ಹೇಳೋದು ಕರೆಕ್ಟ್. ನಾವು ಈ ಕಮಿಟಿ ಮುಂದೆ ನಾವು ರೆಪ್ರೆಸೆಂಟೇಶನ್ ಫೈಲ್ ಮಾಡಬಹುದಾ? ಖಂಡಿತವಾಗಿ ಫೈಲ್ ಮಾಡ್ಬೋದು, ಮಾಡ್ಬೇಕಾ? ಖಂಡಿತವಾಗಿ ಮಾಡ್ಬೇಕು, ಅದು ಕೂಡ ನಾವು ಮಾಡ್ಬೇಕು.
Yeah, I think very extensive submissions should be made to this high-powered committee, wherever, in whichever direction it goes. But very cogent articulation of the multiplicity of the views. Let multiple views go to the high-powered committee. You don't have to sing in one voice. Let multiple representations go to this high-powered committee, except that nobody knows how to access this high-powered committee. Is it in the form of, nobody knows.
Email.
There's one email address. You can write to that email address. What happens after you write to that email address? Are they going to hold some consultations? Or yen ಮಾಡ್ತಾರೆ ಈ representations ತಗೊಂಡು ಏನಾದ್ರೂ ಒಂದು ಕಾನ್ಫರೆನ್ಸ್ ಇಡ್ತಾರ ಅಥವಾ ಬೇರೆ ಕಡೆಯಲ್ಲಿ ಕಾನ್ಸಲ್ಟೇಷನ್ಸ್ ಮಾಡ್ತಾರ? ಅದ್ ಬಗ್ಗೆ ಏನೂ ಇಲ್ಲ. ಸೊ ಅವರು ರೆಪ್ರೆಸೆಂಟೇಷನ್ಸ್ ತಗೊಂಡು ಏನ್ ಮಾಡ್ತಾರೆ? ರೆಪ್ರೆಸೆಂಟೇಷನ್ಸ್ ಕಳಿಸ್ಲೇಬೇಕು. there is no doubt. But ಅದಾದ್ಮೇಲೆ ಏನಾಗತ್ತೆ, we don't know. That we don't know. We don't know what the high-powered committee is going to do effectively, what its mandate is. It doesn't put out any contours of its investigation, of how it proposes to go about satisfying itself on various points. What is it looking at? Nothing. Anything else?
Just to add to the discussion.
One second.
Yeah, so I like what you said about equal partnership and how all of us need to rethink this whole concept of marriage, like heterosexual or otherwise. And also, did you mean, in a sense, the law needs to also look at what an ideal equal partnership would look like? And
I think there has been it's not as if these are, I'm not saying anything particularly new in that sense. I think there has been a very traditional feminist concern about the institution of marriage. I don't know how much interrogation we have done about the manner in which this has played out in courts and otherwise, right? I don't think how do I say this?
like the age of consent for women is 18.
Professor John is the expert on age of consent. It is her exclusive area of work. Any questions on age of consent will go to Professor Mary John. But no, what I'm trying to say is that there is a lot we have to rethink very fundamentally, right? We have gone with this notion that marriage is an unequal institution. There is violence in marriage. There is dowry. There are all of these things. What I don't think we have recognized is how important the institution of marriage is in the absence of every other kind of security mechanism. What is left for you in this country as a 16, 18-year-old adolescent without any serious prospects of employment, etc., that come with what is left, right? So my point is that there needs to be a rethink on very many positions that we have traditionally occupied. There needs to be a rethink from the experience that we have had as with these laws that have existed already, and we've had enough now experience of working with them. The question is, should we be imagining a legislative framework that is able to address some of these very fundamental things of inequity that we have been speaking of? Number one, I don't think it is not a single solution. I'm certainly not of the view that one spectacular piece of legislation is going to bring any answers to these types of inequities or patriarchies or whatever it might be. I'm just saying that we have to start this process of rethinking the positions that we have occupied as feminists when the data seems to be telling us something a little different from the positions that we have traditionally occupied. So at the same time, I will say in the same breath, and it sounds quite contradictory even to me when I'm saying it, that I do believe that there needs to be one comprehensive legislation that is accessible. Which is to say, I'm in agreement with Arvind when he says that, yes, with all its flaws, if two people still want to suffer the problem with the SMA, they should be fully given the right to do so. My only problem with it is that its structure does not allow for its interpretation to be that way, right? So I thought there was something very difficult to overcome in the structure of the SMA itself in asking the court to interpret it in this particular way, right? So I am totally, I mean, I would say, you know, give people a series of options of what they want to enter into. And if they still are choosing the Hindu Marriage Act or the Special Marriage Act, when there is something else that's available, that is one thing. But right now, there is nothing else available except these. Right? These are the only legislative frameworks we have to understand marriage or separation or children or custody or adoption or whatever these questions might be. So I'm still a fan of the idea of a very utopian legislation. I still think that is what one should be gunning for. I'm not saying you're going to get, one is whether you get it or not. That's a different ball game. But to actually begin to imagine it is something that I have a very strong belief in. Yeah.
Yeah. Basically, one thing what we are missing is the entire thing about Shripati Ravindra Bhatt's comments on adoption. That came from a very, very regressive mindset. He also found that they might not be the fit parents, and I mean, that's
not in the best interest of the child.
Not in the best interest of the child. I think that goes beyond like
the scope of what was before him.
Yeah, exactly.
I also just want to open it up to others for comments. Yeah. Yes.
Arvind and Arthur spoke about like imagining a future in the uniform civil code. At this point of time, nobody knows what that is. Right? And so I just want to can I get maybe a short idea of where do you start with that? Do you imagine a uniform civil code where marriage is defined better, or do you imagine a uniform civil code where marriage is not required for several of these rights to flow from intimate partnerships?
Can we take two more questions and then answer? Question. Yeah. Anybody else? Comments? Professor, if you want to. Would you like to say something?
I was wondering, most of the questions seem to be legal. Yeah, I thought you wanted to say this is not about the what's the socio-political part? What's the public education part? And do we want to hear more about what I call husband marriage, which is the Indian story? And I'm wondering whether the fact that legislations have happened elsewhere is when, in fact, marriage was no longer a husband. It broke down. Half the people were not married. Some were single, some were whatever. Any number of combinations happened in other contexts within which then same-sex and other kinds of unions were allowed. We, on the other hand, are in a context where compulsory marriage, as you say, is the one and only for 99% of our population. It's unique. It doesn't exist anywhere. And has that something to do with the way in which the so-called sacred principle of marriage, blah, 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 has in fact been invoked by the courts to claim that then this is not okay. We are not ready for this, right? So I think we need to get a little bit away from the law part of it. I don't know, that's my.
I think you have to explain a little bit about the compulsory marriage part, Professor John. I'm not sure everybody knows, knows what you mean by that.
What I mean is that, you know, I'm saying that on contrast like arranged versus love marriage are non-sequiturs. I mean, they are not the issue. We are living in a country now where really chosen or otherwise, marriage is the only institution available to women, and most men also buy into that for their basic future, economically, socially, sexually, reproductively, and so on. And the question of bank loans and so on comes much further down the line. I'm surprised that we're constantly talking about this. Why are we not talking about the labor that is in fact institutional marriage, right? Without which it would not exist as we know, right? So I'm saying it's all of that within which we are supposed to the idea to choose your spouse versus family does it. We are still in a situation where in fact choosing is a very small number. Most of us would rather have family do the job to this very day, right? Again, unique in our country, to this country, not happening anywhere else in the world. But we do that. We want others to be choosing for us because it is the primary institution for security, for meaning, for social identity and so on. And that hasn't changed. Age of marriage is going up, everything else is happening, but this is not changing. That is the context within which I feel we need to ask what we want from this institution. What's wrong with it? And I don't, you're giving feminists a very good, and I don't think we've done the job. As feminists, I don't think we've gone on about UCC and so on. We've gone on about domestic violence. We've gone on about maybe unpaid labor, but not really about this institution per se where we are. We are big, radical, make radical noises. Most of us are married at the same time. So I think it's full of contradiction, in bad contradiction. Sorry.
Just one more question, if anybody.
Because you mentioned that, like the whole petition about marriage, and especially marriage act was also found a lot of inequalities, and one being that it favors a very specific type of, say, the couple become the succession marriage as well as that. If you could like a little bit talk about the detail and also like in terms of the broader, like it connects to a very broader question of that, is there a selective cooptation and appropriation of bodies, the law? Like it connects to a very activist idea of if the bodies, specific bodies, specific human bodies are getting appropriated. But like also like the connection between that selective inequality.
Sure. I'll just start with Rajesh's question. I think that I think it's the other way around. I think if you're in the business of imagining a particular sort of legislation, you should begin with the imagination of the fundamental principles that govern that legislation, and then think about layering it with the specifics. So and I don't think that any kind of civil union partnership or uniform civil code should be premised on the nature of on a prerequisite of marriage at all. I think it has to be a self-contained code that operates in and of itself completely outside the realm of what we have, so that you effectively have choices available to you of whether you want to go down this road or whether you want to go down that road. This is my personal belief, and I think that the structure of the way, the imagination of a code of that nature needs to begin with the fundamental questions of what is it trying to achieve in terms of the equality of a relationship. Now, this sounds great. The difficulty of it is exactly what Professor John just pointed out, right? It's a problem. It doesn't address what she is saying, right? And that to be honest, I don't know how to reconcile this. It is true that there is a compulsory nature of marriage, which is the only form it's the only form in which that addresses a large number of aspects of one's life. There is no taking away from that. There are a very few select, I mean, in a minority of people who fall outside that particular framework. How does the law speak to that particular problem? Should it speak to that particular problem? Can it speak to that particular problem? Right? What have feminists done in terms of um, uh, asking these types of really hard questions of the institution of marriage? Like I said, I am not of the view that the Uniform Civil Code, what I'm calling the Uniform Civil Code, it could be called anything else. It could be a civil union, partnership, statute, whatever else it might be called, is not the answer. It is the option, that's it. And it is an option with a view to trying to alter, I don't know, the very fundamental inequities that exist. How can you alter those inequities that exist when you're still having the same people coming into coming from the same sorts of socioeconomic backgrounds into that? How is a statute going to address those inequities? It's not. Right? So I'm still, the Special Marriage Act is, the Hindu Marriage Act is a copy of the Special Marriage Act with a few changes to it broadly, right? They read exactly the same way. The only thing that the Special Marriage Act does is to change the nature of how the marriage is to be solemnized. That is, it tells you that you have to register the marriage. There are two ways in which you can register a marriage under the Special Marriage Act. That's pretty much the Special Marriage Act as a legislation. It doesn't have anything dramatically different about it. The curious thing about the Special Marriage Act, and I believe this is under challenge in the Supreme Court, but it's one of those petitions that is just languishing, is that if, to give you an example, if a Hindu and a Muslim get married under the Special Marriage Act, which is actually their only option if they wish to each keep their religious identities, they have no other way to get married in this country except under the Special Marriage Act. Their property is governed by the Indian Succession Act. Anything. So they give up their rights that they would have had as Hindus or as Muslims. But if two Hindus get married under the Special Marriage Act, they're still fully protected by the Hindu Succession Act. So the Special Marriage Act has a very curious relationship to Hindus in particular. It safeguards them in a variety of ways, right? That doesn't happen for other communities. So if two Muslims get married under the Special Marriage Act, they give up their rights under Sharia. They will now be governed by the provisions of the Indian Succession Act. So the Special Marriage Act that way has a very, very convenient, I would say, relationship with Hindus, right? Which for some reason no other community gets the benefit of, right? The other problem that with the Special Marriage Act is the manner in which the marriage is to be solemnized. Especially, I mean, a lot of work has been done in recent years, and there are petitions challenging this 30-day notice period that has to be given before you can solemnize a marriage under the Special Marriage Act. The notice needs to be publicly displayed at the sub-registrar's office, which causes a lot of problems for interfaith couples and so on and so forth. So there are petitions that are challenging the 30-day notice period, which no other marriage statute has. You don't need to give.
Still law.
Yes, from bans. Yeah, that's where they've got it from. Yeah. And they've stuck it into a civil civil legislation. So I mean the statute of the Special Marriage Act requires a serious amount of reform. This is, I mean, something that is fairly commonly, I guess, discussed in legal circles. It requires a certain rethink and a relook in terms of its approach, right? I don't think there's any co-option angle in this at all. I don't think that you could have gone to the Supreme Court asking for it to be registered, to be recognized under the Hindu Marriage Act or the Christian Marriage Act, because all of those statutes look at marriage as a sacred union governed by certain sacred religious principles, etc., which the Special Marriage Act doesn't, because it's meant to be a civil law that is applicable to it. So there was no there was no option but to go with the Special Marriage Act being the site of the litigation. You could not have gone saying let two Hindu gay men get married under the Hindu Marriage Act. It just would not have flown. You would have been stuck with too many problems of how Hindu marriages have been interpreted as being a sacrament, and as have other marriages, etc. So you could not have asked for it. You could have only gone with PSM. So I'm not sure there's any co-option. And was there any other question? No, you have. Of course he has.
What can I add to please understand? Just maybe one small point, which is the question of thinking outside the framework of compulsory marriages and institutes, what Mary was pointing to. And perhaps strangely, ironically, you can go back to the judgment, right, and the minority opinion of Justice Chandrachud, where he's making the point that you can recognize an intimate association under 1916. So what are the rights which flow to that association? What is that relationship really about? What are the liabilities which flow, etc.? That's one kind of a route you have to think about, a framework outside the question of the institution of marriage. That's only one small point.
Thank you so much, Aarti and Arvind. Thanks. We will draw this close now. Thank you so much, everybody, for attending. There's a little bit of a situation where we have few copies of the booklets. More of them will come on Monday. So those of you who can drop by after Monday, please do that. On the website, the booklets are available. The pamphlets are also kept outside. There's no dearth of pamphlets, so please feel free to take for yourself, friends. Please do chat for the communities you work with. I think there's a lot of food for thought for us to think about, especially in the way that you put it, that the question and discussion always somehow, maybe it's ALF that we always come back to law, but the real conversation has to happen on social political understanding and working with grassroots to figure out what exactly is the way forward. We don't want to sort of get stuck in quotes for things that give us such intimate joy in that sense. I wanted to end with a poem of Langston Hughes. It's called Our Land. I'll just read it out, and I think it's a very aspirational poem in the sense that it's also in terms of joy and how we see what would it mean if we had all of these rights that we are fighting for in our world. We should have a land of sun, of gorgeous sun, and a land of fragrant water, where the twilight is a soft bandana handkerchief of rose and gold, and not this land where life is cold. We should have a land of trees, of tall, thick trees, bowed down and chattering parrots, brilliant as the day, and not this land where the birds are free. Ah, we should have a land of joy, of love and joy and wine and song, and not this land where joy is found. Thank you so much. We will keep this copy.